Hey, all persons having anything to do before the Honorable Justice, the appeals court, now sitting in Boston, far within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning. Welcome to the March 1st, 2024 sitting of the Massachusetts Appeals Court. Let me introduce our panel. To my right is Justice Rachel Hershfang. To my left, Justice Christopher Hodgens, and I am Justice Eric Neyman. Ground rules for today. We'll have 6 cases. Each side has 15 minutes to present argument. There is no rebuttal. You will note that we go by the clock, so when the red light goes off, that means your 15 minutes is up. Please stop your argument at that point. If the panel wishes to give you more time, we will do so. I can assure you that this panel has read everything. We've read your briefs. We've looked at the case law. We are very familiar with the record, so I would urge all counsel to cut to the heart of your legal argument. However, your time is yours to use as you see fit. Final housekeeping matter. On occasion, you will see the justices looking at their computer or iPad or laptop. I assure you, we are not looking at the funny pages. We are not looking at the sports pages. We are not looking at our emails. We have the record and your briefs and the case law available to us, and we're simply checking things in real time. So with that, we will call the first case, Commonwealth versus Floyd, 23P461. We'll hear first from counsel for the appellant. Good morning, Attorney Rose.
Good morning, and may it please the court. My name is Rachel T. Rose, and I represent Lewis Floyd. A defendant is normally entitled to a specific unanimity instruction if they request it and if there is any possibility the jury might disagree on what incident comprised the charged crime. Now, extortion is a discrete crime. It's not a continuing offense. This court has previously held that specifically in 2003 in Commonwealth v. Megna, 59 Mass. App. Court 511, where the victim was named in the indictment and the Commonwealth provided the violent threats that the defendant used to part him with his money in response to a motion for a bill of particulars. So this isn't the same as the armed robbery situation in Commonwealth v. Santos, because the extortion statute doesn't punish the aggregate effect on the listener, it punishes the threat itself. So to convict in Santos, the jury just had to agree that the reason the victim turned over their property was because they were scared. But here, something Floyd said to one of the witnesses needed to be a malicious, violent threat that was seriously intended to make someone do something that was against their will. Even taking everything each person said at face value, there are good reasons to accept or reject each of the different calls with Krellin, Rutkowski, or Lieutenant Huard as meeting the elements of the statute under the instructions that the jury were given. Krellin's call contained the most outrageous violent threats, paired with a deadline, but no real demands. Rutkowski's call did contain a very general demand for action, but paired it with a threat, take matters into his own hands, that held only a weak suggestion of violence. The call with Lieutenant Huard contained both violent threats—
Let me interrupt you right there.
Sure.
How would you distinguish Fan from this case? As I understand Fan, the court held that there was a pattern of conduct. I understand it wasn't the extortion statute, but the court held that it wasn't directed at individual victims. It was sort of, I'm actually trying to quote from the case, but there was a pattern of acts directed at a number of different people. How is Fan distinguishable, or how is this case distinguishable from Fan in a legal sense?
So in Fan, they did not actually present any testimony from the victims. They presented testimony from what advertisements he put to get people to come to these women. They presented evidence of how he ran his business, but they didn't have anything from any of the individual victims that the jury could either choose to believe or not believe. I believe her, but not her. In this case, it's different calls with different people. None of them heard the other calls, and so the jury is making an individual assessment of each person as to what
even in the Fan case, isn't a jury free to believe some, all, or none of the evidence that is presented to them? So in Fan, they certainly could have credited some of the information presented to them, but not others, which would have presented the same conundrum, ostensibly.
Well, because they didn't have—
Do you agree with what I just said?
Yes, but they didn't have different things that they could either choose to credit. He placed these advertisements and he did these things to run this business, or he didn't. You can't. There's no theory of the case that has he placed one advertisement but not the others, or he rented this place to run his business, but he didn't rent some other place. There's no question, either he ran this business or he didn't, because all of the evidence has to do with his course of conduct in running the business. None of it had to do with this happened to me and this happened to me. I do want to go back to the third call with Lieutenant Ward. It actually did contain both violent threats and the most specific demand of the three to intercede with local authorities on Floyd's son's behalf, and that had the strongest evidence of his identity as the caller. But it was the least plausible as a serious attempt to compel action because it was made to the police who were arresting him.
But isn't there a common denominator among all three of the calls? I mean, essentially, there's a threat made to compel people in the office to take some action on behalf of the caller, and if they fail to do what the caller wants, then he's going to take some kind of adverse action against them.
Well,
I mean, isn't that really common to all the calls?
Yes, all of the calls had the same aim, that they wanted help for his son in his unsafe situation. Whether any of them actually contained a malicious, violent threat that was intended to get them to do something against their will for that is somewhat questionable. If some of the jury here thought that this was an extortive threat to the named person, Lieutenant Ward, to get the police to come kidnap his son or whatever, and some of the jury thought, oh, well, that doesn't count, that wasn't a serious intended threat, but with the threat that was made to Michelle Krillin, that's the, heads are going to be dismembered, that was an extortive threat. And if they disagreed on what that was, then he didn't get a unanimous verdict from the jury. Because the indictment didn't name a victim either, which is not usual in these cases. With this theory, there's also a real danger of variance between what the extortive threat was that he was indicted for and what was the one the jury considered to have been proven at trial. Disagreement seems particularly likely here because it's questionable whether any of the threats fulfilled the intent requirement. This isn't a classical extortion case because it has nothing to do with money or any kind of personal gain. The statute as written allows for an intent either of gain or to get the victim to do anything else against their will. But this doesn't make a lot of sense on its face because every word in the statute is supposed to have meaning.
Well, let me ask you that question. What is the precedent? I understand the plain language of the statute. What published cases are out there from Massachusetts that involve the second prong of the statute, the non-pecuniary situation?
I believe it is only the one case, and I think both of us cited it in our briefs. It's where the guy was extorted into giving up his job. He was asked to step down from his position. But that is the only one I could find. Cases like Matchett, Manchester, and most recently Haverhill Stem v. Jennings in 2021 treat the issue of this statute. Because, of course, the entire statute is supposed to have meaning. But if the second bucket of the statute are things against the defendant's will...
I'm going to have to ask you to slow down. You're going very quickly. Sorry.
So things against the victim's will is going to include giving the defendant your money. So the statute as written is a little odd because... why would you need the first part of the statute for, doing this for personal gain or to get someone to do something against their will if, giving something against their will is going to include giving him my money? All the personal gain motives can be folded into that bucket of things against the victim's will. So most cases just sort of write that out of their definitions of extortion. But even if you take the words of the statute exactly as broadly as they were written, how can you extort something that the victim wants to give you? The employees told the caller they'd like to help him and promised assistance. Without the threats that frightened them into calling police, they likely would have ended up contacting the local authorities as he wanted them to do. But even if the help the witnesses promised was unlikely to be forthcoming, being told from the beginning that they wanted to help him means that by the plain wording of the statute, the threats weren't directed at action that was against the victim's will.
Well, the language of the statute is actually with intent to compel any person to do any act against his will. So here you have people saying, we cannot do X. We cannot get Rhode Island to do X. And the response to that is, do it, or I'm bringing people down to bomb the place. Do it, or I'm going to have some people come down there and shoot you up. Why doesn't that fit the bill? Because against their will is something that they don't want to do. It's written as volition. It's not written as something that they can't do or something that they wouldn't have otherwise done. It's something that they don't... against his will. Against his will. And what is the best case interpreting that language, if there are any? Oh, there aren't any, I'm afraid.
But blurring the definition between extortion and any other threat to commit a crime was the theme of this case, and it was why the Commonwealth took such pains in their questioning and their closing to bring out that the caller made other threats that had nothing to do with extortion, even under their very expansive theory. It was also why those other threats in that closing were prejudicial. I would just like to briefly discuss the instructions. Despite arresting Floyd while he was still talking on the cell phone they said he had just used to commit the crime, it was not seized as evidence. He was arrested at the end of the last call to the Children's Advocacy Center, and some minutes later, the phone was used to place another 15-second outgoing call. Clearly, it was accessible to and being used by someone other than Floyd, who was at that point sitting in handcuffs at the back of a police car. Unlike the calls of the police...
What is the evidence that he was sitting in handcuffs at the back of a police car at the time the call was made?
He was arrested directly after, they plucked the phone from his hand at the end of the call, and he arrested him. As to exactly where he was sitting, I can't say for sure, but he did not have control over the phone at the time.
Or whether he was handcuffed. The person who arrested him was a high school friend, right?
I believe Officer Guerrero did testify that he handcuffed him. But unlike the calls with the police, none of the witnesses at the CAC knew Floyd or could even compare the caller's voice between the calls, because they each only took one. That the number showed up with his name on the caller ID doesn't mean anything other than that he'd called
Well,
them
wait a
that
minute.
number before.
Maybe I didn't catch what you said, but I thought one of the troopers played football with him in high school, and he was very familiar with
Oh, yes,
the sound of his voice.
The police knew who he was. The last call...
Oh, they not just knew who he was, but knew the sound of his voice.
Yes, that's what I'm saying. The last call with the police had much better evidence of identity than any of the calls with the employees. And that matters because if the jury understood the judge's instructions to mean that they should determine Floyd's identity as the caller to a lesser standard than beyond a reasonable doubt, the calls to the CAC employees might fall in between that area, between a preponderance of the evidence and proof beyond a reasonable doubt. Because the verdict of guilt might have been based on those calls, with Floyd's identity found to that lesser standard, the instructions could have substantially risked a miscarriage of justice.
So the instruction, you're talking about instructing the jury that they must find basically authentication by a preponderance of the evidence.
That's correct.
There are a series of cases, two cited by the Commonwealth in their brief, and most recently there's a case, I don't think either of you cited, Commonwealth versus Alden, 93 Mass Ave Court, 438, which holds exactly that this is the appropriate instruction to give juries. It's not mandated, but it is appropriate to give. What do you say to that?
In this particular case, it's confusing because that is the only evidence before the jury. The jury is asked to make the two separate determinations to different standards of proof, one after the other.
Wouldn't that be the case in every single case? Because if we're asking the jury to determine authentication of an issue by a preponderance of the evidence, they make that preliminary finding, and then they go on to determine whether or not the Commonwealth has satisfied every element of the offense by this defendant beyond a reasonable doubt. How is this case unique? Because
it is the only evidence. So in most of these cases, you have them determining to a preponderance of the evidence that this is a piece of evidence that we can tie to this defendant. This is a piece of evidence that we can use against him. And then they take that piece of evidence, and in their second determination, they're using it as part of a whole to see, well, if we add all of this up, does it come to...
But we see this a lot. For example, we see this in violation of 209A cases, harassment cases, harassment prevention order cases, where the contact is through, might be through a cell phone, might be through a telephone call, it might be through a text. The issue is whether or not the person who made the contact is this defendant. So the authentication question in those cases first goes to the jury as an evidentiary threshold by a preponderance of the evidence, but then the jury must unmistakably find proof beyond a reasonable doubt of the elements and that this defendant is the one who made those calls and committed that offense.
And it's much more difficult to make that error if you're being given that instruction as the piece of evidence comes in, that you can only use this piece of evidence if you find it to be the defendant to a preponderance of the evidence. Here, however, it's a little bit different because they didn't get anything on the subject until right at the end. And then right at the end, they got, well, you should find his identity as the caller to a preponderance of the evidence, but then you find his identity as the criminal beyond a reasonable doubt. And when the calls are all you have, unless you're listening really closely, it's very likely that they would have interpreted those instructions to mean we should determine that he was the caller to a preponderance of the evidence, and then once we've found that he's the caller by that standard, we determine whether that's a crime to be under reasonable doubt.
So let me ask you this. Are you making the argument that just in this limited case, this limited type of situation, the instruction is unfair or inappropriate? Or are you making the argument that we shouldn't be asking juries to make an evidentiary determination by a preponderance of the evidence in a criminal case?
It can be, I mean, I think it could be confusing in other situations than this one. This one, I think it's particularly problematic just because you don't have that initial instruction when the piece of evidence first comes in, so that you can see this as something different than what you're supposed to be doing at the end of the case when you're totting up everything to beyond a reasonable doubt.
Do you, I actually run aground a lot earlier than Judge Neyman appears to. What can you say to the question of whether a phone call from the defendant or an alleged phone call from the defendant as to which the only evidence in trial is witness testimony is like or unlike actual pieces of evidence, for example, text messages, screenshots of Facebook postings that are themselves offered in evidence? Did that make any sense as a question?
I'm struggling with it a little, but
Okay, so here, let me try again in English, and I apologize because I'm using up your time. What we have here is phone calls made by the defendant. There's no piece of evidence. There's testimony about them. What we have in Alden and the other cases, the names of which I can't remember, is actual stuff, pieces of evidence. Are those the same or different?
they would seem to be the same. It's whether you're crediting that witness testimony as it is the same as whether you're crediting that piece of evidence as an authentic thing. That is what it appears to be, the same way that you're saying that these phone calls that they're saying I have to do with this case because they're from the defendant, that is an authentic piece of testimony that we can credit as if we had a voicemail from the caller. I would like to say, 15 seconds, the COVID issue. This trial took place in May of 2022, and COVID was still enough of a concern that potential jurors had been rejected over it. Individual Vardir was particularly poorly suited to cure prejudice in this case. He announced to the jury that he was positive, and then he kept testifying. That's it. If there are no further questions, I'll rest on my brief.
No, thank you very much. And we will now hear from the Commonwealth.
Good morning, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I'm going to go in order of the issues, but you're certainly welcome to ask questions on any issue because I realize there's 6 of them, so I'm happy to answer questions on any issue. The Commonwealth charged extortion in this case, and the calls went into, there were 19 calls in less than 3 hours on one morning to the Children's Advocacy Center, and the calls were taken by 3 of the employees there, and then 2 police officers who were reported to the scene based on the calls by the Children's Advocacy Center to the police.
What case can you cite that involves not pecuniary advantage, but the other prong of the case, intent to compel any person to do any act against his will?
So I think I rely on Nichols in my brief, where the person was giving up a legal right. Now, that might have had a pecuniary portion and part of it, like someone's going to make money off of it when you give up your pecuniary right. But also the statute itself doesn't just say financial, it says any act against your will.
Right, I've just never seen it in a non-pecuniary context, that's why I ask.
Right, and then in terms of the threats portion of that, I rely on Hamilton, which is a probation officer, and then that's not extortion, that's a threat to a probation officer saying that some act, it's like a vague predatory threat is being made against.
They analogize it to Section 25, right?
Yes, because threat is part of the charge in this, part of the elements of this case. So that's why I rely on Hamilton, where you have a public employee being threatened that they're a family member, not themselves, based on what the public employee is doing. So in terms of the threat portion, the threat element of extortion, I also rely on Hamilton. But Nichols talks about giving up a legal right, and also one of the cases I cited, there was actually a debt owed. The evidence didn't prove that the debt was not owed. It was that the person was threatening harm in order to get repayment of a true debt. So I would suggest that also isn't, while it has a financial element to it, the money actually belongs to the other person because it's a true debt in that case. So
Nichols,
Just
a quick question. Nichols is an 1883 case. Did the statute read the same in 1883?
I don't know. I didn't check that. I'm sorry.
That would be particularly important to our analysis, right?
Well, I don't think it's that important to the analysis when you look at the language of the statute, which doesn't say it has to be for a pecuniary interest. It says an act against the person's will. And so my sister is arguing that these demanded acts to assist in the Rhode Island custody matter are not against the employee's will because it's outside their jurisdiction. And I don't think that that's a reasonable reading of the evidence here, because the employers are getting the call and they're saying, we don't serve that area, we can't help you. Let me, call and find a person you can call. Well, of course, later on when he's talking to Trooper Guerrero, he's saying, talk to Rhode Island, they weren't helpful. Like, he knows who he's supposed to call. He wants these employees to use the power of their authority as Massachusetts public employees to interject into a Rhode Island matter where he hasn't been able to get any help from Rhode Island. And they are not willing to go outside of their jurisdiction to help him, and that's when the threats begin. And these are very obviously malicious threats. I mean, they're peppered with misogynistic comments about women working in the public sector and that we're causing all the problems. But in addition to that, there are threats to dismember. The threat to Officer Huard was to dismember a female's head, threats to shoot up the place, light up the place. This is a place where forensic interviews of sexual assault victims who are minors takes place. And those forensic interviews were going on, which the second person who answered the phone told him, like, I'm going to go do my interview, and then I'm going to make some calls, and I'll get back to you at 3 o'clock. Like, she doesn't get any threats from him. She's saying, I'm going to make some calls. But he's told what's going on there, and Huard says to him, you're scaring these women here. And he says, I want them to feel real fear. And that is the essence of extortion, to scare someone into doing something that they don't want to do. And that is why the Commonwealth has charged this case.
Who is the person? So the statute criminalizes doing the threats with intent to compel any person. Who is the person in the Commonwealth's theory of the case?
It's the women at the CAC. Now,
particular ones of them?
I think it goes to all of them, and that's why I rely on Hamilton, because the person being threatened is the child of the probation officer. And I know that's a single person here, but he's calling and he's making these claims to any person he can get hold of on the phone. And then you see in Officer Ward's testimony where he says a female head will be dismembered. So it's all the women at the CAC are, and I would note, the indictment does not have a named person. It's just this other person. It follows the language of the statute.
And given that it's sort of a collective, non-legal person that the Commonwealth is putting forward as a victim, how does that affect what your sister says is the need for a unanimity instruction about which statements were at the heart of the jury's verdict?
Right, so I don't think you need, I know Matchett and Miller have the language of a named person. The statute doesn't have that. The statute says another person. And here, he doesn't care which woman he gets. He says a female head will be dismembered. He doesn't care that it's Krellin or Sousa or Rakowski on the phone. He's saying he's going to come down there and it's all the women's problems. So he's going at all the females there. And I would suggest that that's sufficient under the statute. And as to specific unanimity, I suggest that this is 19 calls in a less than 3-hour period. They all share the same motive, help me with my son custody issue in Rhode Island. They all share the same anger towards women. They all share the same type of threats. I'm going to take matters into my own hands, take the law into my own hands, bring my guys down and shoot up the place, light up the place, dismember people. And so that theme, and they're all from the same phone call, all with the same caller ID. And so I would suggest that this is a situation where the jury would believe all or nothing.
So it's a continuing course of conduct.
Continuing course of conduct under Fan and Santos. And I understand Santos is a robbery case, but I think that's a good example. You can rob a whole bunch of people. Like, you get all the people in the elevator, everybody in the elevator is being robbed. And so instead of charging each individual offense, the proper unit of prosecution, is one, because he's doing this all morning until he stopped. And so that's the Commonwealth's position on that. I don't have a case on point. This is an unusual circumstance for a public office to be getting these types of threats, and these are unusual threats. So this doesn't happen every day, so I don't have a case right on point, but the Commonwealth's evidence is solidly within the elements of the crime here, and the jury's verdict is well supported.
Let me ask you about the authentication issue. I've read the two cases you cite, and as I said, recently in the Alden case, we reaffirmed this principle. Why are we asking jurors to make a determination of authentication by a preponderance of the evidence? Isn't that a classic judicial gatekeeping function?
It's not the only time you have that kind of gatekeeping function. You see that in voluntariness of statements.
But humane practice, the jury must find beyond a reasonable doubt that it was voluntary.
I understand. I'm just saying that kind of gatekeeping is not necessarily just for the judge, because the jury decides whether to credit evidence or not credit evidence. But
why shouldn't that be beyond a reason? If we're going to throw it to the jury, why shouldn't it be beyond a reasonable doubt? It seems strange to me, because I really think it is a judicial gatekeeping function, but even assuming, because our case law has said it's for the jury, shouldn't the jury have to find, because they ultimately do, beyond a reasonable doubt, that this defendant made these calls?
So I respectfully disagree. I think it's proper for the jury to make this determination, because the instruction says you can't even consider the contents of the calls until it's authenticated by a preponderance of the evidence. So they don't even get to the threats within those calls until there's a preponderance of the evidence that it's the defendant.
Then shouldn't the instruction, if that's the case,
I'm sorry?
Shouldn't the instruction, if that's the case, go on to say, if and only if you have determined by a preponderance of the evidence that the defendant is the one who made these calls, then I instruct you, you must and can only find the defendant guilty if you make that determination beyond a reasonable doubt. I know that they later get into that instruction, but why not then and there immediately clarify and mandate the instruction so that there is no risk of jury confusion?
So I don't think there's any risk of jury confusion here, because the judge's instructions on reasonable doubt were very strong. I know they're not exactly right after the authentication instruction. They're in the burden of proof where they belong, and the order of the instructions is not determinative. We look at instructions as a whole. And this is also for a substantial risk. This is the one issue the defendant did not preserve for the record. And so in this case, the Commonwealth has very strong evidence of identification. So I would suggest this is not a proper case to change the law, but...
Well, let me rephrase the question. Do you think it would be better and clearer to tell the jury, after providing the preponderance instruction, to immediately reinforce the ultimate burden of proof beyond a reasonable doubt then and there?
I do think it would
so.
be clearer after you give that, to give it contemporaneously, but that doesn't create a substantial risk not to. And in fact, there's no error in these instructions. The judge is following the law that we're all bound by. I believe at least one of the cases is a Supreme Judicial Court case, but I could be wrong on that.
I don't think so.
Is
I
it not?
think
So
these
it's
are all
Justice Foster
extensions
F. And
they're a logical extension of Purdy. That's where it comes from.
but that's the judge was following the law that he was bound by, because he's bound by this court's decision. And so I would suggest there's no showing of an error. There's no substantial risk here, because Trooper Guerrero answered one of the calls, and the defendant said, "Hi, Kevin, it's me." He recognized his name, he recognized his voice, they talked to each other as if they knew each other, and then Trooper Guerrero went and arrested this person he knew, who he identified at trial, while he was on the phone with Officer Huard. So in this case, it's very clear, the evidence is very strong that the defendant is the identified person, and the instructions show that identification has to be beyond a reasonable doubt.
Let me just ask you quickly about the prosecutor's closing, because there was an issue as to the admissibility of some evidence of the defendant's part of the defendant's call was he made a reference to threats to a family in Tiverton, Rhode Island. And the judge very carefully evaluated that evidence and determined ultimately it would be admissible, but it was clear that it was a kind of a dangerous area to be going into, because there's a risk that the jury might consider that evidence improperly. But in the prosecutor's closing, she actually discussed this evidence for some reason. She said, in connection with that call, she tries to calm him down and point him in the right place, the right people of contact. I'm sorry, let me go back a little bit. She tried to point him in the right place, give him the right information, but rather than taking that information from Ms. Krellin, the defendant became irate and threatened that family in Tiverton, Rhode Island during this 13-minute and 30-second phone call starting at 8:46 in the morning. The caller did not take Ms. Krellin saying she could not help him but could point you in the right direction. Instead, he turned and began threatening people. He threatened to put 2 in the back of the head of the family in Rhode Island. It's an implied threat with a firearm. Why would she go into that?
The prosecutor's a he, and he said, he also noted there's no direct threat at that time to the CAC when he is discussing that in his closing. So it's evidence that came in that the prosecutor can reference. That evidence was important because it goes to the intent of the defendant and the identification of the defendant, and it's the first time he says something that troubles Michelle Krellin. So that's what gets the ball rolling. That's why that evidence is properly admitted in the judge's discretion, and that's why it's proper to talk about in a closing argument. And he noted that that's not a direct threat to the CAC, and there was an instruction saying that that was not, could not be the basis of a conviction in this case. And so I would suggest that that was a proper use of it in the closing argument, and if this court finds otherwise, the instruction cured it. I see my time is up.
Anything further? No. Thank you both very much. Well presented, and the case is submitted. Thank you.
Thank you.
Our next case on the list, docket 23P 748, Commonwealth v. Russell. Morning, Attorney Renaud.
Thank you, Your Honor. Good morning, Court. Should I, one moment, or are we ready?
I think you can begin.
Thank you, Your Honor. Suzanne Renaud for Nathan Russell. Your Honors, this case is here on interlocutory appeal, and for the reasons in the brief, the motion judge's decision denying the motion to suppress should be reversed. And this case, the very first and primary question comes down to the moment of the stop. Because if the stop didn't happen until after this purported firearm was abandoned, or, then the Commonwealth's arguments in what the judge said below would prevail. So this really comes down to, ultimately, did the stop occur earlier? In particular, the moment that, it's a little amorphous, but the moment I'm kind of identifying is when they enter the curtilage of 6 Blodgett Place. So that very private area of somebody's house that the police at that point don't know whether or not these men knew anybody who lived there. It's a very private area, and that is the point that I'm sort of pinpointing at the very latest, is when the police were actually effected a stop. Now, clearly, there is not physical touching in this case. It's about pursuit. And the court's been very clear that pursuit is enough to effect a stop. There isn't a magic word that has to be used. Just like when we have an arrest, you don't have to say, you're under arrest. It's the behavior, it's the conduct that indicates whether or not a stop has occurred.
So to what extent does your case hinge on whether or not this falls under the, let's call it the Commonwealth versus Warren umbrella?
I think that Commonwealth versus Warren is clearly the case that is sort of, that was cited in the application for interlocutory appeal.
Either this is a Warren-type case and you prevail, or it's distinguishable from Warren and you don't. Is that fair to say?
That's essentially what I'm conceding, that if it doesn't fall into that, then I think the judge would have gotten it right. But she didn't get the moment of the stop correct in the first place. She also didn't get her assessment of reasonable suspicion correct, but the stop is the first question to address.
So I want to ask you a lot of questions about that, and I will try to make them as brief as possible. The police were not in view at the moment you have identified as...
I disagree with that.
Sorry?
I disagree with that.
Why?
Well, because this is one of the problems that the judge made in her fact-finding. She didn't incorporate what she had in front of her, the record that she had in front of her. The police very clearly were close enough to see these two men, to see they were frantic, to see that they were pacing. When we are talking about this distance, we're talking about 200 feet.
When you
Right.
say the police, you mean the initial officer or all three?
So there were,
Sorry to interrupt.
I'm sorry, I think we have two different time periods. Would you like?
Yes, and so I don't want to talk about that early part. I want to talk about the moment you have just identified as the moment of seizure. And my question was based on having viewed that 10-second video repeatedly, because it's fabulous, and knowing that in the frame, now I have no idea how far that distance is, and for the record, nobody knows because it's not part of the record below, but when the video starts, Mr. Russell is already within the curtilage.
Yes.
So in your view, he has already been seized, am I right that
Yes.
far? And you cannot see the police officers in the frame.
But I think that you have to take the whole situation as a whole, because there are, first of all, people don't, it's not just visual, it's also audio, not to forget that. When they're in the yards behind 163, which is really probably 173 Eastern Avenue, and the police officers are capable of seeing them, looking frantic. They can't identify them yet, but looking frantic, pacing around. There are the detective, the two officers in full uniform are there looking down. Now, to the extent that you want to use Google Maps and say, well, this part was wooded, this part wasn't. I mean, we do have some indication, I think minute 124 on the audio, that they're talking about the street in between Rodney and Eastern being Verlander, which could be the extension. But even if you don't say that, the pictures actually show that these are yards. They aren't fully wooded. And so the police are close enough. They're making radio traffic. When you see them come out in that piece of the video that you're talking about, they're not being stealthy. They're not, hunting. They are walking as fast as they can.
Walking.
They're walking. They're not running, but they're walking. With purpose through woods. But I guess the point is, at least at that very initial place where it's clear that these two men are taking off, the police can see them, and they're talking. I think that and that is in the context of the two, Mr. Russell and his companion, already knowing that a police officer was there right before that. That I think that you can't divorce that and say that they never saw them and didn't know they were coming. What was the motivation for them to flee, if not for the fact, to the particular place where they did, if not for that fact? So I think you cannot make the assumption, and since this is the Commonwealth's burden, to establish the moment of the stop, you can't just say simply they never saw them. If the police officers can see them, it's
Right, and I
reciprocal.
think, it's plausibly a fair inference from the record, though it is not one that was made by the judge.
I would say would disagree on that point.
That they took off running because they recognized that Officer Denio was a police officer.
So here's what I would say to that. The judge did not make that conclusion, draw that conclusion in her findings, right? And again, her findings were not using the video and audio evidence really to the extent that they should have been. But what she did was on her first determination, when she's trying to say, when did the moment of the stop happen? And she's trying to analogize it to a very different case. She says, there's no indication on the record that they saw the police officer. Literally the next paragraph, when she is trying to explain why there's reasonable suspicion, she says, there's reasonable suspicion because they saw the police car. you cannot draw two different, that's clearly a fact-finding error. You cannot draw two different factual inferences based off the exact same set of original facts.
I think I see what you're talking about, and I disagree with your interpretation of it. So the first statement was, there is no evidence in the record that either the defendant or his companion was even aware that the police were following him. And the second statement is, presumably upon seeing Officer Denio's vehicle, the defendant and his companion started running across private property, which alarmed the residents. Are those the two statements you're talking about?
Those are the two statements.
So I think it is possible to interpret the first as, I'll start backwards, interpret the second as, oh, expletive deleted, there's a cop, we better head out, and the second, or the first, as second in time, we didn't know that the cops were following us.
Well, I would also say that, and I think this is difficult, there is not no evidence. That's a backwards way of saying it. There clearly is there direct evidence? No. Is there inferential evidence? Yes. The judge here did not make a finding rejecting the inference that they saw the police officers. In fact, if they're started by running, and then now, again, I just want to emphasize, because she...
Police officers, and seeing the police officers and running because of that is one thing. The police officers following them and them knowing that is different. They're not mutually exclusive.
When the police officers end up on Verlander and Vincent, again, they're very, very close. I would also point out that all of this, from the time the police officers start, I think this is 1:08, and to the time to say that it's not them, which means they're prone on the ground, is 1:37. We're talking about less than 30 seconds in this whole thing. So we're talking about the police officers coming down. They had already, so the way
let me ask you about that before you go any further, because I thought that was interesting. Listening to that audio, isn't that compressed?
No.
In other words, that's not real time, is it?
There's no indication it's not real time. That was submitted by the Commonwealth.
Because there seems to be, I mean, that's almost nonstop chatter
Yes.
on that turret tape, which doesn't really make sense unless they've compressed it for the purpose of just convenience.
It was a dragnet that was going on at that time. So people are talking. This is the other part where I'm saying that, you're talking about three officers get together at 1:08 and start walking down, which happens to be the moment when these two men, just as they are starting to walk down, that's just when the two men kick off, there's all this chatter going on the radios, which they're wearing. I mean, so yeah, there's constant chatter going on during this whole period as well. And they are coming fast. And at that point, even if, I think this is the problem with the case that the judge was using when she made that statement, is there's no evidence that they're following. That case was such a different case, because that case was a man who was on a public street and there was a police officer who was walking behind him. This case, what we have, it's like the equivalent of a police officer being in a car saying, hey, come here, and then them not coming, and then suddenly getting out of the car. And that we consider to be
No, but it's
pursuit.
not, because there's been the police officers did not, in this case, approach, address, or attempt to restrain the subjects directly at any point until they're behind the place at Six Plaza Place. So,
Well, they did, I think, again, what are we talking about when we say they're approaching? Because you have the two men in the backyards. You have not one, but now three officers suddenly coming down the stretch, which is partially, it's wooded, obviously, but partially, visible. This is when they take off. These officers are going fast. That is pursuit.
there's no evidence of the speed at which the officers are
Well,
traveling.
we know that they had to have been, Your Honor, because we have a picture. I mean, whether you want to accept the distance or not, that is not, it's the equivalent of like 6 house lengths also going over a street. And they did that in 25 seconds. They are going fast. And that's where I'm saying that the judge's fact-finding here is problematic, because she never even looked at that. And if you take all of that out of the equation, No, there's no direct evidence from the officer's testimony. You're right. But when you look at this and you say, well, what kind of inference can you draw? There is no other inference other than if they are doing that in 25 seconds, they're going quickly. They might not be running, but they are certainly going quickly.
I'm going to ask a question that reveals my ignorance of Massachusetts criminal law, which is probably a dumb thing to do on the bench. In the federal system, a defendant may testify at a suppression hearing, and then that testimony is not usable in any way against the defendant.
Unless they
at
take the
trial.
stand, yeah.
Unless they take the stand. Is that also true in the state?
I actually, because I don't practice in Superior Court, I couldn't tell you definitively, but I think that's the same here. I don't think it's anything different. We shouldn't be putting the onus on him.
I mean, that's the whole point of being able to testify, or part of the point, and not have it used against you, is it's not burden shifting. But I'm just trying to explore in my own mind whether there was another perspective of evidence available at the time of the motion
I'm
hearing.
going to take it back just one other moment, though. If you look at the opening statement that his attorney made, he fully expected this police officer to say that we made eye contact when we were on the street on Eastern Avenue, and he even asked a question, and the detective denied that. So when you're talking about should Mr. Russell have taken the stand, I mean, maybe...
I'm not asking if he should have. I was wondering if he could have.
I mean, yes, he could have, but if that, I have not seen the police report, but if the police report indicated that there had been eye contact made, and that was why the legitimate basis for that question, that certainly changes the strategy going into the motion to suppress. So I'll just put that out there. But I think that when you look at the behavior, I think the last part of this is when you look at the behavior that happened within the curtilage, why are they pacing around? Why are they hiding a firearm if that's what they're doing? There only is one reason, again, or one really logical inference for all of that behavior, and that's because they knew the police were coming. So when the judge made the statement that there is no evidence, there's no direct evidence, I think all of this other circumstantial evidence points in a completely different direction. And when you combine it with her original statement that she knew that the detective was on Eastern Avenue, I think that really makes a huge difference.
Let me ask you
here.
this, because if there's going to be a rule of law, it has to be one that everyone understands, particularly the police. So if we were to create a rule of law that you're asking us to, it has to be very clear, thou shalt not do this, or thou shalt do this. What in this case would we be telling the police that they did wrong?
Well, that's a really good question, Your Honor. And I've been thinking about this, because if all of this happened on the street, because this is I think there's some language in Manaus, if I'm remembering correctly, and I'm sorry, I'm running out of time here, but that talks about, Stout, that about the nature of a pursuit, and that creates a stop. If this was happening on the street, then maybe the police officer would be creating an FIO, because the judge's other factual finding that was incorrect here, just to make sure I get to this, on page 18 and page 30, the officer said, I wanted to talk to them, which means that he was trying to get to them. So that's the other piece that adds into all of this. If he was doing that on the street, it would be an FIO. When you're doing it on private property into a curtilage, there's no way you can construe it as that. So in terms of the law you're trying to create here, it's that this is going to be some kind of stop. Whether it's a consensual stop like an FIO, that's fine. If it's in this situation, which is highly unusual, it's not fine. And then you need reasonable suspicion, which for the reasons I've stated are not existent here.
Your time is expired, but you can finish your thought.
Yeah, thank you, Your Honor. So I would just say that they're not making a new rule in this particular situation. I think what's happening is that we're applying rules, the Warren rule, we're applying other rules in the facts of this case, and I don't think you need to be thinking about this as something that's groundbreaking. It's something that's just application of rules that we already have. If there are no further questions, I'll rely on my briefs. Thank you, Your Honors.
Okay. Thank you. Commonwealth.
Good morning, may it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the order denying the defendant's motion to suppress. In this case, the motion judge properly found that the police conducted a lawful stop warranted by reasonable suspicion, And I'd point to the Franklin case that states, following a person presumably at a rate of speed sufficient to keep him in sight does not amount to a seizure absent some additional assertion of authority by direct verbal communication or otherwise. And in this case, the record before the court contained no evidence of any police action that would have communicated to the defendant that he was not free to leave. There was no display of intimidating or assertive conduct, no show of authority, no attempt to stop or restrain the defendant's movement while he was followed through the woods. The officers who joined in uniform did not draw their weapons, did not attempt to speak to the defendant or issue any warnings while they were following him. And as discussed, there is no evidence, direct evidence in the record that the defendant or his companion were aware that the police were following them.
Let's talk about what the video, though, allows us to I'm not going to say assume, to deduce, which is, it looks to me like there are 4 officers in that video, and it's unclear whether there are 3 or 4 of them. Is that actually unclear, or is there an answer in the record? The judge found there were 4.
I believe on the record, the officer that testified at the hearing said 2 officers responded with him. So I do believe that it was 3 officers.
Okay. So they emerge from the woods. The first one, Officer Dunnia, was in plainclothes, but the later 2 guys obviously are in uniform. They come out of the woods. The defendant and his companion have taken off running. They've leapt a fence. How is that the same as slowly rolling up on someone in a Crown Vic on a public street?
So I would say at that point, they're no longer just slowly following them. At that point, they've been following them since Officer Denio drove around. I believe it was on Vincent Street that he parked, got out, could see them through the wooded area. The 2 officers respond, they get out, and then they start following them. At that time, their pace might have quickened because they see them jump the fence, they can see them knock on the door of the private residence, kind of rustling around I think it was a sandbox. So at that point, I think it's gone from maybe just walking alongside and seeing, but even if they are running, I think it's the Perry case that Judge Dontel cited, even running after a running person without more doesn't constitute a stop. And at that point, they still hadn't made any commands. They still hadn't said, stop, get to the ground, police. It wasn't until, my understanding is once you kind of see in the video, you see them converging, and then you see the defendant and his companion kind of realize what's going on, and then they kind of jump the fence, and that's when the orders were issued to stop. That's when they were ordered.
My memory of the video is that you do not see the police officer until after Mr. Russell is in the curtilage, has already jumped the fence. And I think, one of the evidentiary facts here is that we don't know what Mr. Russell and his companion could see from there. We only know what the camera captured.
Right, and I think we can't just assume that the defendant knew the police were that close to them, because if you see the video, the brush in the woods that they're walking through, they're quite high. I think they go to chest length or higher. So I don't think we can say for sure that the defendant knew the police were as close as they were, but regardless, you can see them coming on the video, and at that point, I don't think there's any dispute that the defendant knew the police were there.
You cited the Franklin case, but that predates Warren. How do you distinguish Warren from this case?
In this case, I think there were more factors relating to the reasonable suspicion that the officers had to rely on. So it kind of took everything. If you start at the initial dispatch of they were investigating a fleeing shooting suspect, Officer Denio, who's in plain clothes in an unmarked vehicle, sees the defendant, loosely matches the description that he heard on the radio dispatch. In the vicinity where the shooting suspect had fled, they start running through private property, startling the residents that are there.
But you don't make the argument that there's reasonable suspicion until the police see the people in the curtilage, right?
I would say
hiding the stuff.
A totality of the circumstances. I think all of these instances accumulating with them seeing the defendant kind of wrestling around the toy, that's what creates the reasonable suspicion. But I think it's not just seeing the toy. I think it's all of the behavior leading up to that as well.
I don't know that the analysis hinges on the degree of reasonable suspicion initially. I think the point of the Warren case is that certain types of pursuit constitute a seizure.
Right, and I
I think that's the greater point. So in that respect, can you distinguish this from Warren or no?
I would say the best response I have to that is that there was no evidence that the defendant knew. There was nothing to his state of mind to know when the police were in pursuit of him. So all we have is the police officer's testimony regarding all of these factors that led ultimately to them ordering them to stop.
Let's assume he did know. Let's assume at the outset, there's evidence that the defendant saw the officer in plain clothes and they took off because they recognized him. Does a police officer violate Article 14 or the Fourth Amendment by saying, well, we're looking for a shooter, and there's someone who conducted the shooting was wearing a dark hoodie, and they see one of the two people wearing a sweatshirt with the hood up. Is there anything wrong with the police officer walking, following them? Does that, in and of itself, violate the Fourth Amendment?
So I think in that case, it would be, you have to take into effect that the officers were investigating a shooting, they received information about an individual with a gun, and the test then for determining whether there was reasonable suspicion to pursue should include the consideration for the government's need for a prompt investigation. I think which the Commonwealth isn't saying, but if for argument's sake the stop occurred, are we saying that as soon as the defendant ran up the first driveway? Is that what you're asking? Is that if that's when the stop occurred?
What I'm asking is, what's wrong with a police officer armed with certain information walking after a person, walking in the direction of a person who is sprinting away, if the officer has some basis to believe that they're investigating a crime? Does that implicate, or I should say violate, Article 14 merely by walking in their direction?
I would say no, because they were investigating a crime. I think the officer had the right to act upon that. It was an active investigation. He sees someone who loosely matches the description. If he was to get out of his car and start walking up to him, at that point I would say he was just investigating an active shooting. So I would say that no, that wouldn't.
And then, so just to play out the blow by blow, the officer gets out of the car, he starts walking up to this person who, loosely meets the description. The person takes off running. We don't know, and we know that the defendant and his companion took off at what an officer might call a high rate of speed. But we don't know, because the record doesn't show, how fast the cops followed them, right?
Right.
So Mr. Russell and his companion take off running. Officer Denio and his two companions follow them. Is that a seizure? Under Article 14, not under the Fourth Amendment.
I think it would all depend on whether the defendant knew he was being followed, because I think the officer does testify that after that first initial, when the defendant and his companion run up the driveway and startle some residents, after that he testifies that he's still in his car, he never left his car, and he moves his car, and he lost sight of them. So we can assume that this wasn't happening at such a fast rate of speed, that he had them in his sight line the entire time. He was able to drive around the block, kind of get in a different position, and still from his car, he still hadn't got out of his car when he sees the defendant and his companion kind of, I think frantically pacing is what he said. He hears a neighbor yell, "Get off my property." That's when he calls for assistance. He's still in his car while the two other officers respond to the scene. It's not till all three of them are there that they get out and then start kind of following them through the wooded area. So I still think there was enough time between the initial interaction, if we're saying that the defendant recognized the police officer and ran from that, there was enough time in between that there wasn't evidence showing the defendant knew that the police were still there following him or pursuing him.
So in your view, it matters whether the defendant lost track of Officer Denio between the time that they first were in each other's vicinity and the time that Officer Denio was joined by his 2 uniformed colleagues,
Yes.
and the defendants took off through the backyards.
Yes.
There's no evidence of that.
There's no evidence that the defendant didn't know they were there? Is that what you're asking?
Well, there's no evidence either way of whether the defendant knew or did not know
Yes.
that the officers were there.
Are there any further questions?
Yeah, I have a
Probably.
question for you. Back to the turret tape. So my memory of turret tapes is that the recording is going to be collecting them from the entire city during a certain period of time. So it might be from the west side of the city, might be from the east side of the city, and all this is going to be collected in, let's say, a half-hour time period. When you request that turret tape, they're only going to give you the transmissions that are connected to your particular case. Isn't that right?
That's my understanding.
Yeah, and it's going to be compressed too. So it's not going to be, you're not going to have a half hour of dead time.
Right.
It's going to be kind of in rapid fire, the transmissions. Isn't that right?
My understanding, but I could also confirm with the Superior Court ADA whether that was a compressed version. That's my understanding, but I could confirm.
So in other words, we shouldn't be drawing too many inferences from the timing of transmissions
Right,
on
yes,
the
'cause
turret tape.
As discussed before, if you do listen to it, it is kind of rapid speed, one after another. There is no dead time. So it is my thought that it is compressed, but I can confirm.
And just one other question. So if we were to assume there was some wrongdoing by the police here and we had to invoke the exclusionary rule to deter police misconduct and suppress evidence that was seized as a result of that misconduct, what evidence was seized from the defendant?
Apart from the firearm?
Well, the firearm wasn't seized
Wasn't
from the
seized
defendant, right?
You're right. Yeah, there was, to my knowledge, there was nothing.
So does that have any implications for us?
The fact that nothing was seized from the defendant?
Yes.
Off the top of my head, I'm not sure.
In other words, there was no evidence seized from the defendant
Right.
as a result of a stop, an unlawful stop, assuming it was unlawful, right?
I think it's a softball.
Right, yeah. I mean, sure, and I think that,
It's not a trick question, in other words. I'm not trying to trick you.
right, there was no evidence seized from the defendant. I think as stated, one of the arguments in the Commonwealth's brief was that the gun was found in a place where the defendant didn't have a reasonable expectation of privacy, and the officers saw the defendant kind of over there rummaging around before they ordered him to stop. Are there any further questions?
Seeing none, thank you.
Thank you very much.
This case was very well briefed, and the case is submitted. Thank you both. Our third case today, 23P646, Commonwealth v. Anding.
Good morning. May it please the court, Rosellen Elcoury for the Commonwealth. The question whether there was probable cause to issue a search warrant is a question of law that this court reviews de novo in a common sense manner and realistic manner. This court considers the facts contained within the four corners of the search warrant affidavit and the reasonable inferences that can be drawn therefrom. And the warrant is read as a whole without overly parsing or severing it or subjecting it to a hyper-technical analysis. So a reviewing court should also give considerable deference to the magistrate's determination of probable cause, and doubtful cases should largely be determined by the preference given to warrants. And that is a cite to Anthony, 451 Mass 59, pages 68 to 69, the 2008 case. In the incident case, the defendant's motion to suppress contended that the Commonwealth failed to establish both prongs of the Aguilar-Spinelli test in its search warrant affidavit. As this court is well aware, the Aguilar-Spinelli test is a two-pronged test arising where a search warrant affidavit relies
on a confidential informant. In that case, the two prongs that the Commonwealth must prove is first, the basis of knowledge of the confidential informant, which in this case is not in dispute, and second, the veracity.
Yeah, let's cut to the chase. Are you arguing that the veracity prong was met here, or are you arguing that there was enough in the basis of knowledge in totality, basically, and enough corroboration to overcome the lack of satisfaction of the veracity prong?
We're arguing essentially that there was sufficient corroborating evidence to meet the standard required for the veracity prong. So
the latter?
yes.
Okay.
The attitude when considering a search warrant under Aguilar-Spinelli should not be a grudging or negative one. Instead, we look to the fact that a magistrate must be informed of some of the underlying circumstances from which the affiant concluded that a confidential informant was credible or his information was reliable. And obviously, a search warrant should not be dissected and then have each fragment separately subjected to a hypertechnical test of its sufficiency standing alone. In this case, when considered with a common sense approach, the search warrant affidavit established probable cause that the firearms sought would be found in the storage unit described. And in the Commonwealth's brief, I do go through the corroborating evidence that we believe assists in meeting that veracity test. I'm happy to reiterate that for the court at this point. But if there are no further questions.
Let me just go off.
Some questions coming.
Let me just go off a little bit as to where you're going, stepping back. I know we're looking at the four corners of the affidavit, but I am curious. The Commonwealth didn't initially file any written opposition to this motion. Is there a reason for that?
I don't want to speak for the attorney who was assigned this case. I think she had just recently joined our office and maybe hadn't been fully caught up. If you look at the transcript, I think the judge was aware that our office was going through some transitions at the time, so it may have just been an issue of oversight and catch-up. But she did ultimately file a written decision, again, at the judge's direction, and it was not clear from the memorandum of decision whether the judge relied primarily on that written opposition or the elements raised at the oral argument in reaching the conclusions that she did.
The other thing is, this affidavit had a lot of information that was not particularly germane to the firearm being found in the storage shed. It went into the whole narrative about the drug trafficking operation and various players involved in that. Is any of that helpful?
Absolutely.
How so?
A lot of it is helpful. The easiest example that I can pull off the top of my head is that the confidential informant gives the trooper information about a particular individual who has recently been released, according to the informant, recently been released from jail, lives in a specific area of the town of Dennis behind a specific restaurant, is known to carry firearms, and is known, according to this confidential informant, he has not, or he, they, she, has knowledge that this individual traffics in cocaine and fentanyl. As this investigation progresses, the trooper gets in touch with the local police in the town of Dennis and finds out that there has been an incident with that particular individual who is at the apartment complex identified by the confidential informant, behind the restaurant identified by the informant. He accidentally shoots himself in the leg having a firearm. This individual is on parole, which means that this incident prompts a search of his home, and crack cocaine and fentanyl is recovered. And all of those details from something that is seemingly completely unconnected to this firearm and this storage unit goes to establish the veracity of the information that the confidential informant has been providing to the police. It's not a conviction or information that led to an arrest, but it does say that there is reason to believe that this individual is not lying to us. This individual is giving us information that is accurate. So other examples are the car that was in the repair shop. It's all little things that are seemingly unconnected, but I would argue go to establishing the affiant's ability to say, all right, this is someone whose information we can rely on when we put it in a search warrant. And that's why there is so much seemingly unconnected information in there.
Okay, so you're saying that even sort of innocuous details or details unrelated to the firearm in the storage shed, that just the verification of those details are enough to say, okay, if the informant's being truthful about these details, then the informant's likely to be truthful about the details about the firearm in the storage shed.
When you're dealing with a first-time informant, which this appeared to be, you don't have a history to fall back on reliable information they've given you in the past. You have to find, if you're the affiant, other ways to establish that veracity. Sometimes it's through independent police investigation of elements pertaining to the specific issue that you're using your search warrant for. And sometimes, as in this case, it's, all right, here's information about this greater sort of drug trafficking operation, and we can see where it matches up. And so I think that is why that information was in there.
The judge took issue. Am I correct that the storage unit was in the co-defendant's name?
It was in the girlfriend of the co-defendant's
Co-defendant's
name.
girlfriend's name.
Yes.
And the gun was alleged to be the co-defendant's, which the judge made issue of, in the possession of the co-defendant.
Yes.
And the judge also took issue with the fact that the defendant's presence at the storage facility without being seen in the specific unit was unhelpful. Why is the judge wrong on those two counts?
Well, in the first case, just dealing with the issue of possession, as this court is aware, actual constructive and joint possession are not separate theories of the case. They are, oh wow, I've
Well,
lost the
does it
word.
even, I guess
There are different ways of defining the same principle. So the fact that this defendant was never seen actually holding the gun or actually exercising, opening this particular unit is not the issue. And then beyond that, the standard is probable cause. We have a person in a place, and I believe when he's seen by the trooper on his own at the facility, it's, I believe, about 2 weeks before the date that the police go to the unit itself. So it's a pretty short time period. It's, the confidential informant claimed that they had gone there with the defendant and its co-defendant a few days before they took the police there. So it's a compressed time period, and it stands to, it's a reasonable inference that rises to the level of probable cause that this individual could have been at the storage unit to access that unit and possibly the contents thereof. So for that reason, I think that the fixation on whether or not this defendant was directly observed in that unit or with that weapon is perhaps a little premature. I would also state that if you look at, again, the statement of the confidential informant, but they did state that the defendant and co-defendant together discussed using this firearm supposedly to settle a score that this defendant had. And so that could also speak to possession.
There's an argument, I don't even want to call it an argument, there's sort of like a thing that happened at the suppression hearing where defense counsel threw in that apparently due to, I assume the Commonwealth had provided potentially exculpatory information in advance of the hearing, that the defendant himself also had a unit at the storage facility. Am I right in thinking that's not part of the record before the judge?
As far as I'm aware, it was not. It's not clear to me, I'm sorry, at what point the Commonwealth did become aware of that information or when that information did become available to defense counsel. I don't think there was ever any accusation of any attempt to withhold information or not include information in the search warrant affidavit. It does make the case a little bit closer, but closed cases, we tend to lean in favor of the probable cause determination of the magistrate.
Thank you.
Thank you so much.
Attorney Zandrowski.
All right. Good morning. I'm here today on behalf of Marcus Anding, and as this motion is regarding the validity of the search warrant, this court's review is de novo, so I'm going to just jump right into, I think, the meat of the case, which is whether the police had corroborated the CI's information with independent investigation.
So I gave you a preview of coming attractions with my final question to the Commonwealth, so let's get at this.
Sure.
Does it matter that the gun was ostensibly belonging to the co-defendant and not to the defendant? The judge makes a lot of that. The judge also makes a lot of the fact that the defendant was seen at the storage facility, but not without any details that he was accessing the unit at issue. It seems to me that either there's probable cause that the gun will be there or not. It doesn't have to. We don't have to prove at this point that there is probable cause that this defendant was in possession of the gun. That's a trial issue, right?
I think it would still go to the evidence that would come in against Mr. Anding. I think to separate out those 2 points, I think him just simply going into the storage facility doesn't necessarily mean he accessed that unit. There's no corroboration. So I think that's sort of what I would call an innocent observation from the police of him just going into the same building that the unit happened to be in. And I think...
Well, it's certainly a weighty factor, isn't it? You know, the tipster says, gun at this facility in this unit, and in a fairly related time frame, the defendant is seen at that same facility.
I think it's similar to perhaps the Hill case. I cited defendant in a house. I think it's sort of similar where we don't know how many units are in the facility. It's a facility that's open to the public. And so simply going into a facility without anything further doesn't particularly connect Mr. Anding to that unit, to the firearm. And I think similarly, just merely being in the presence of that firearm doesn't necessarily indicate criminal activity, according to the CI's allegations there. And so I have a few other innocent observations. I guess something that the police had observed when they observed him going into the storage unit, they observed him in a blue Dodge Charger. And nobody else, the CI doesn't identify that Charger as any of the rental cars that the defendants used. The police don't corroborate the fact that Mr. Anding was barred from renting from Enterprise, which is a fact provided by the CI. There's no other times, dates, makes, models of any kind of rental cars that Anding was using, allegedly. I think that while police did observe him at firearms store, that's an innocent observation because he explicitly did not purchase a firearm there. And then the person who had purchased the gun, Sherry Blue, wasn't connected to anything else in the case, apparently. Her name only comes up at that particular point in the affidavit. The police made a number of observations unconnected to Mr. Anding. They observed a Hyundai SUV in a repair shop, but there's nothing connecting Mr. Anding to that other than the CI's words that he was part of the same organization. No connection between Mr. Anding and the rest of that group. Same thing, the Malik Farrell information, the individual who went to the police provided some information that he says that Marcus Anding owned a green pistol and he stored it in a motel room. This doesn't corroborate the CI who didn't identify any color of the firearm. The police never observed Mr. Anding in a motel room.
Yeah, but isn't that, wasn't there some corroboration there from that there was an allegation that the defendant suspected there was a rat in the organization, and that it was this particular fellow. And as it turned out, he actually did make a report to the police, and he's actually named in the affidavit. Doesn't that tend to be corroborative of the information? And it's coming from a third party. It's not from an independent police investigation. This is a third party reporting something to the police that corroborates what this informant is telling them.
Yes, but I think that it sort of corroborates that these two know each other, but it's pretty far removed from this storage unit, Mr. Walters, kind of anything else in the case. It seems to show that there's some connection between Malik Farrell and Marcus Anding, but I don't think anything more than that. And so, oh, and also, Malik Farrell reported that Marcus Anding puts up photos of this firearm on Facebook. Police didn't corroborate that. And then we have the 62 Baxter Street, that trap house, that supposedly the CI says that Marcus Anding and his drug organization are packaging drugs out of. He provides a photo of the kitchen where all this is allegedly happening. Police do not corroborate that photo, if that photo was an accurate representation of the kitchen. Mr. Anding is...
How could they have done that?
I'm not entirely sure, perhaps through a window, or if they'd gotten a search warrant. But, I mean, as it stands, it's just a photo of a kitchen. I think importantly here, Mr. Anding is never connected to that house. There's no evidence that he was ever there. And we know that the police...
Well, there's a testimony of the CI. Are you saying if you don't believe the CI, there's no corroborating evidence?
Yeah, I think that is what I'm saying. And we do know the police had the house under observation as early as October 2019.
With the poll cam, you mean? You're not saying there was continuous physical surveillance of the house. I don't think there's any evidence of that.
I don't think continuous physical surveillance. We don't know when they put the poll can up. That's not in the affidavit. But we do know they had observed Darrell Russ going into that house, and he was apparently murdered in October 2019. So he had to be there before, and police were apparently observing 62 Baxter Street for months and months before the CI even was aware of Marcus Anding. So, and there's a number of things that the police simply just didn't corroborate. The CI had provided information that Marcus Anding's girlfriend was applying for a license to carry, and that would have been easy to corroborate. They did not. The CI got the name of who the storage unit was in. He said it was in Mr. Walters' name, or he or she. But it wasn't. It was in his girlfriend's name. So they were simply wrong on that information. Police didn't corroborate the information that Marcus Anding stores drugs in a car with a tarp on a certain street.
Even if it's in the girlfriend's name, isn't it still corroborative for probable cause? Again, the issue, maybe I have this wrong, but it seems to me the issue is not whether or not there is proof that this defendant possessed that gun. The issue is whether or not there's probable cause to believe that that gun is in that unit of that storage facility, right? And then it becomes a matter of proof as to whether or not the Commonwealth can satisfy its burden of proving that this defendant possessed the gun.
Or the reliability of the informant in giving that information, I think. And so him being wrong on who that storage unit, whose name that storage unit was under, I think is relevant. And I think, too, this one is pretty important. The police never actually make any connection between Mr. Walters and Mr. Anding. That all comes in through the CI. There's no indication in the affidavit that they are connected.
Well, yeah, but, I mean, they did in sort of indirectly, though, because as I read the affidavit, at one point, the informant joins the police as they go to the storage unit, and he's able to point out to them precisely which unit he's talking about, where the firearm is. And he had also indicated to the police that he had been to that unit with both of the suspects involved here to look at the firearm. And in your brief, you said on page 14, you said there is no indication that the CI willingly accompanied the police. Why would that be important?
Well, I think because the cases the Commonwealth cited sort of indicate where a CI has a willingness to accompany police, that sort of their information should be treated as more truthful or kind of goes to their veracity. That they're, I think, to speak colloquially, they're willing to put their neck on the line, they're going to go with the police. And so I take issue with the word willingly, just that there's no evidence that he voluntarily went. It's just that the police transported him, sort of a kind of a neutral description rather than him leading the police there or going willingly. So I think, my issue is with the willingly phrase.
I want to go back to your criticism that there was no evidence that tied Mr. Anding to Mr. Walters or the operation. In paragraph 5 of the affidavit, it says, during the month of June 2019, which is approximately a year before the CI seems to have been recruited, members of the Cape Cod Drug Task Force initiated an investigation into the drug and firearm trafficking activities of Marcus Anding and Dajian Walters at 62 Baxter Road, Hyannis, Mass. So I guess is your argument that it doesn't add to that we should sort of ding the veracity of the CI because he or she didn't explicitly draw that connection, of which it appears the police had been aware for over a year?
I think that the CI draws a connection between the two, but I think that the police don't provide corroboration of that, and I don't think that paragraph 5...
Isn't it corroborative to say we have been investigating this for over a year already?
I don't think that provides any kind of specific information other than that they were investigating it. I don't think there's enough detail there to say that they observed them together, any kind of activity they were doing other than there's some kind of investigation going on. So I think that it's a little too vague there to go that far.
Final question from me. Acknowledging that it's always a fact-intensive analysis, would you say your two most important cases are Hill and Rojas on this?
Yes, I think so. If there are no further questions, I can rest on my brief.
Well argued by both counsel. The case is submitted.
Thank you.
We're going to take a brief recess.
All rise. My pleasure.
Okay. Good morning. Calling our fourth case on the list. Docket 23P 430, Doe v. Sex Offender Registry Board. I'll remind counsel that this case is impounded. Please refrain from using any names of the parties or people involved. Counsel, you may proceed.
Thank you. Good morning, members of the panel, and may it please the court. My name is Emir Shahich, and I represent the appellant, John Doe. I am requesting that the court lower my client's classification from a level 2 to a level 1, as the decision was arbitrary and capricious for at least 3 specific reasons, and there was a lack of substantial evidence warranting a level 2 classification. First, over the appellant's objection during the final classification, the hearing examiner allowed unreliable hearsay and made an impermissible finding that an anal rape occurred.
So let me stop you there. To what extent does this entire case hinge on our determination of this issue? Because it seems you raise it as a standalone issue, but you also reference it with regard to all of your issues in this case.
Correct.
So if we agree with you, it seems that you prevail. If we disagree with you, would you agree that all of your issues are out the door, or no?
I do not. And then the other reason, I will get into further reasons why that is. That's under the factor analysis, specifically degree of dangerousness, rule 30, the factor 33 that was applied with respect to the risk of recidivism, but not degree of dangerousness, and was given no thought. And that's the factor 33 was familial support. Now, regarding the issue of this finding of anal rape, the hearing examiner conducted his entire analysis as if the anal rape was the index offense. So normally, a defendant is charged with a sexual offense that qualifies for registration, and it goes either to trial and it would be found guilty or not guilty. If found guilty, that's beyond a reasonable doubt, and then would be subject to registration. If he pleads, that's the same as the guilty, and he's found guilty beyond a reasonable doubt. But here what's going on is the appellant, he pled to 2 underlying offenses. So these are underlying offenses of rape. And I would point out that they were indicted first. So the kind of the timing of this whole case is fairly strange and unique. Whereas there's a first report, there's a first indictment. The first indictment only references, or first case only references the first 2 charges, assault to rape and indecent A and B. And then 3 months later, there's a second report, this time a different report. I would not say it's a more detailed report. I would say it's a different report, an inconsistent report that includes more information that was relayed at any given point to Detective Zontini in the first case.
She insisted in that second interview that she was, quote-unquote, anally penetrated.
Correct. And I bring this up because there is on September 29th, 2020, during the sentencing hearing in Barnstable Superior Court, the prosecutor read facts into evidence. In the record, page 238, lines 7 and 8, the ADA stated, the victim said that she was having a hard time and that he couldn't penetrate her, but that she could feel the defendant on top of her thrusting his body in the area of her vagina. Those are the facts that were read into evidence by the Commonwealth, who then null-prossed the charge of rape. And then I would also point out on the record at 244, it states that the victim was, quote, on the call, and that she heard everything that was said. In fact, I believe it was on record 245, lines 1 and 2. The ADA states, the victim has been apprised every step of the way. So the point I'm trying to make is that
Sorry, when you say 244, 245 of the record.
Of the record.
You're talking the record appendix?
Record appendix.
Okay, thank you.
And in that point, the ADA says the victim is apprised every step of the way. And what she is saying on the record is that the appellant could not penetrate. So now going back to the hearing examiner wrote a 38-page decision, but limits his analysis of this reliability, this core issue, the main issue, the issue that we objected to before we even started the hearing. We wrote a motion in limine. I was actually the one doing it, writing the motion in limine to exclude those references. When I made those requests, there's only, after all of that argument and all of the analysis, it comes down to one statement, one single statement. And what he said at R422 on page 9 of his decision, the last paragraph was, although the appellant was not convicted of rape, I find that the victim's statements to the police were reliable and detailed. He had difficulty penetrating her vagina, and her telling him that she was menstruating to find that the appellant did anally penetrate the victim. This is a total non sequitur. This is faulty logic. There's nothing that actually explains how those 2 points equals anal penetration.
I mean, if that was all that was in the record, I think you would have a better argument. But the record also contains the report and the testimony of the detective with whom the victim spoke on multiple occasions.
Right.
So could you address why, in light of that evidence, your argument still stands?
Thank you very much for that opportunity. So first, the testimony, the evidence that was presented during this hearing was all hearsay, multi-level hearsay. The officer, the detective, did not testify. The detective wrote these reports. The reports are based on what was allegedly said. And I would also point out that during the actual recordings, the actual interviews of both of the appellant and the victim, that was never audio recorded, not one time. Okay. So I would point out that in his own statements, in his own writing, the detective indicated that he himself was inaccurately reporting or was inconsistent. In the record on 66, he writes, quote, I likely made a false assumption, end quote. Furthermore, when he gets to the grand jury and he's now testifying, he shifts all of the days around and he says that they spoke to, that the victim spoke to her aunt. Now, I use aunt in air quotes because it's not an actual aunt. So a very focused, particularized review of the record shows that this aunt is just another person that lives in the community. So October 10th of 2018 is when the sexual assault occurs. That's the assault to rape, indecent A and B. 2 days go by. On that second day, the first complaint witness would be this so-called aunt. The aunt in the record on page 67 states, so in the detective's report, he says he meets with the first complaint witness on October 12th. When he testifies, he says it was on October, I think the 11th, and then the board argues that it was on the very same day of the assault, which it never happened. Because he actually indicates in paragraph 1, she told me about the assault. Miss Redacted told me that Miss Redacted lives in the same home as her. On Friday, October 12th, 2018, the victim called her phone and told her that she needed to tell her something. She remembered her being extremely upset on the phone. So it wasn't until 2 days later that the first complaint is made. Then they go meet with a lawyer. Then the lawyer calls the police station. They then go to the police station, and then they make this statement. And what does she say? Her statement is, he pulled my pants down and tried to have sex with me. He was having a hard time. He was struggling to penetrate the vagina with his penis, and that was record 23. She wasn't completely sure if there was any penetration, and there was no mention of anal rape whatsoever. So you have this one report. Then you have this second report where now there's talk about erection and that there was an anal rape. But there's also further evidence. So the detective says, why don't you go...
There's her statements to the detective. There's also her statements, which he says are consistent with the statement she made to her primary care nurse practitioner during an appointment in October of 2018. I mean, your points are well taken. You advocate for inconsistencies, you did so below, and you do here, and you do a good job of it. But to say that there's no corroboration or that there's no other indicia that she did anything other than disclose something to the police detective does not seem supported by the record.
So the issue is, if we go back to that statement of the aunt, he testifies on the grand jury that she said that there was a rape. However, in his own notes, he says that she could not go into any explicit details regarding the incident. So that is the only time he has a conversation and doesn't put that in his own report. That is a fundamental change. Now, under preponderance of the evidence standard, I'm arguing that even on an index offense, I argued in my brief, we should be using a higher standard. Why? Because you have to be convicted of the index offense to even start registration.
Should use a higher standard than what?
Preponderance of the evidence. It should be at minimum clear and convincing evidence. And I think the reason for that,
I do have authority for that
I
proposition.
don't. And there's an SJC case, 2023, I believe, that they said for the first time we're considering this. This is any subsidiary fact comes in as a preponderance of the evidence. But I mean, bad facts make bad law all the time. And what I'm arguing here is that in this situation, it's fundamentally different too in this regard. We're dealing with a classification, not a reclass. We're dealing with the same incident.
Are you saying justice to the governing offense? So in other words, if a hearing examiner is going to make a determination using hearsay,
Correct.
on the issue of what the governing offense was, the standard for that underlying finding should be clear and convincing evidence rather than preponderance. Am I stating your argument correctly?
Correct. And
your authority for that is basically fundamental fairness and due process.
And the contrary, and looking at the actual case, the SJC case that was decided.
Which one?
It was
3177.
Yes, Your Honor. And in that brief, like they talked about, it was a reclassification hearing. They talked about it was like I think the information on it was there was like a separate act, multiple parties. I mean, we're talking about multiple dates. We're talking about 5 minutes, less than 5 minutes, one incident, underlying offenses of the main charge, a charge that came in afterward. Now,
Let me ask you this, though, because we got to keep in mind that, you know, you're not making this argument to us in the first instance. You know, we're here, you know, on appeal, and I just lost my place where I was going to read it from. In the follow-up interview, if I were the hearing examiner and I read the police report, I think it might have been page 65, actually. If I were reading from that police report and I'm the hearing examiner, why couldn't I just make a determination as a fact finder as to what the underlying facts were? And when the victim comes in and the officer is asking her again, you know, what happened, and asking about penetration, and she immediately interrupts and says, "Oh, no, you know, I was penetrated," and then he follows up and he wants to know how, and she says anally. Now, that's in the report. Now, why can't the hearing examiner accept those facts as the underlying facts?
Because, Justice Hodgens, that would be arbitrary, right? Because you have two different statements that are made by her, multiple different statements. And in fact, you actually have a medical evaluation that's done in a timely manner. And in that timely manner, what happens is they're saying there's no tearing, no signs of physical injury. I would also point out that with regard to the request for a sane examination, she didn't go. So there's all these questions, and at a minimum, there should have been more analysis and to explain why there could be two separate statements that there was no penetration, a middle statement, one statement that says there was, and you just embrace that. That doesn't make any sense.
But I mean, it's a very difficult task to be a hearing examiner, and isn't this what we are asking the hearing examiner to do, to evaluate all of this information?
I think the standard, even under preponderance of the evidence, the standard is such that to decide that issue, if you have equally balanced information on a particular issue, you haven't met preponderance of the evidence standard. And that's really what I'm arguing. All of this has been under the preponderance of the evidence standard. Now, I do want to just touch on briefly the other arbitrary issue. The second issue I would argue is that Dr. Bard had his report discredited, and if you look at this precise language, the reason it was discredited or conditioned in some way was simply because he didn't address the factor of degree of dangerousness, which is not what Dr. Bard was there to do in the first place.
Well, looking at the examiner's decision, what the examiner says is, I disagree. The examiner doesn't say why, which may be another problem. I plan to speak with your friend, Mr. Shanai, about that. But isn't the hearing examiner entitled to determine what weight to give the evidence?
Absolutely. However, in Doe versus Sorb, 483 Mass 131, it's a 2019 case. I think they're citing a case which says, where there is uncontradicted testimony concerning subject which is beyond the common knowledge and experience of the finder of fact, that testimony may not be rejected without a basis for such rejection in the record. And there was none. We had all this reference to dynamic risk factors, general self-regulation, sexual self-regulation, attitudes supportive of sexual assault or intimacy problems. We had 8 witnesses, 5 family members.
Your time is up, but I'm going to let you finish your thought. Go ahead.
Thank you. We had so many witnesses that were present that talked about these factors that was never even mentioned in that conclusion. And so, in essence, what's happened is this is just rampant burden shift that's been coming that I don't think is fair, and clearly we don't get to the level of Class 2, moderate degree of dangerousness or moderate risk of recidivism. Thank you.
Let me just check to see if there's any further questions. No. Thank you, counsel.
Thank you.
And Attorney Shanai.
If it pleases the court, David Shanai for the board. Doe 3177 was actually my case, and I remember that case because it's one of the few times I've ever won in front of the SJC. And that case really resolved the issue of the standard of proof for underlying hearsay evidence. It was pretty right on direct that the subsidiary findings are done by preponderance of the evidence. So I don't think that's really an issue here that the court needs to resolve.
What do you make of counsel's argument that because this finding goes to the index offense, it's not a subsidiary finding in the same way?
Every part of all subsidiary findings, including the fact, in fact, Doe 3177 went to the actual sex offense. That was the basis of the reclassification. And again, the court said you can use a preponderance of this evidence standard to determine whether or not the hearsay was reliable to establish that the sex offense occurred. And trust me, the sex offense allegations in that case were wildly inconsistent, and which was one of the reasons why I was surprised at the court. I wasn't surprised that they adopted that standard. I was surprised that they actually agreed that that hearsay evidence was substantial enough to be reliable. Because there were a lot of inconsistencies in that statement, in that woman's statement, and there was independent evidence that for instance, she was in claimed part of it happened in a store. They looked at the videotape. There was no evidence of a sexual offense in the store. And she also had motives to lie. So the court, pretty much went through that and still found that there was enough evidence to make it reliable.
And you don't see any, principled difference or difference that we need to concern ourselves with between the offense, the underlying offense for an initial versus a reclassification?
No, I mean, that's the whole basis. In this case, you have the actual sex offense. So we are here because it was a conviction. So once there's a conviction, the hearing examiner has the right to look at all the evidence, including the evidence that surrounds the actual sex offense, to determine what the scope of the sexual behavior was. And that's what the hearing examiner did here. And the hearing examiner made some findings and determined that there was penetration. Now, I think I argued the hearing examiner's position pretty well in my brief, but I think the reality is if you take the forest from the trees, even if there wasn't penetration in this case, the fact that the sex offense was pretty egregious. It occurred in 2018, less than 3 years prior to the hearing examiner's classification hearing, and more importantly, the individual involved has mental instability issues. I think a 2 is fair in these circumstances. I don't see this case as a level 1. If this had occurred 15 years ago, I think a level 1 argument is much stronger. But the reality is, no matter whether there was penetration or not, it was an egregious sex offense.
Back to the I'm sorry, just a real quick question, and I apologize, I should have asked your brother counsel this question. Was this issue or this notion that the standard for determining the actual governing offense should be by clear and convincing evidence raised either before the hearing examiner or before the Superior Court.
I do not, I know it wasn't raised before the hearing examiner. I'm not sure about this period. I don't believe it
We'll
was.
double check the record either way.
Right. I think I didn't raise that argument because it technically wasn't in the brief that I was arguing against, so I didn't go into whether or not it was briefed or argued down below. My memory of the case is that it actually wasn't specifically argued, but don't hold me that. I've reached an age where my memory can be faulty
Right,
at times.
the record will control. That's fine. And Justice Hodgens has a question for you.
Thank you. Let me just touch on something that I think you just mentioned, and I think counsel was sort of driving at, and he makes a compelling argument, if I'm understanding it correctly, that when I see these SORB cases, I'm always struck by how between the regulations and the courts, there seems to be a real effort to make the review, very rigorous and very thorough, and almost in a mathematical sense, going through the factors and so forth. And yet, we have a case like this where there was a very strong case that was put on. The letters were extraordinary, I thought, from family and friends and so forth, and taking into account the mental struggles that this individual has had through the years. Is there some fundamental unfairness where you could take this very same case and put it in front of one examiner, and you come out with a level 2, and you could put the very same facts in front of another examiner, and you could come out with a level 1? Is there something unfair about this entire process?
Well, I've been in district court, superior court. I found that there's a reason why you have judge shopping. Each judge has their own particular ideas about certain cases and certain crimes. When I was doing criminal law, I did the old Earl Weaver. I kept index cards because back then we didn't have a computer to keep track of which judges made which rulings on what type of cases. You're going to have, because there's discretionary authority, you're going to have some differences. But there's a basic guideline that the board's regulations are trying to achieve, which is certain high-risk factors can be ameliorated. And in this case, the hearing examiner said that this individual's future probation, the strong support network he has, his stability in the community, all reduce that high risk of the recency and egregious nature of the sex offending behavior and his mental health issues to a moderate level. And I think that's a fair way to look at this case. I don't think it's a case where if you take out the idea that it was penetration, that it automatically becomes a 1. And I don't think you take out that his support system automatically makes him a 1. I agree it was strong support system, and the hearing examiner, I think, went to lengths to go over that support system and explain how important that support system was in the decision-making process. Rarely do I see a hearing examiner write 5 pages regarding the support system. And in this case, the hearing examiner listened to the testimony, read the letters, and really focused on that as a reason why there's a reduction in this individual's risk and danger. Another hearing examiner may look at it differently. I think this hearing examiner looked at it very well. I think what you have to look at in the end, and I think it's quoted in my brief as in the standard review for hearsay, is that it comes down to, was the hearing examiner's decision reasonable based on the facts presented? And that is the position that the board is that right now the level 2 was reasonable based on the evidence that was presented. Whether or not it was penetration or not penetration really isn't germane to that issue. It was a reasonable decision looking at all the facts of this case and applying the factors.
Presumably, unlike Earl Weaver, you didn't kick dirt on the bench and get kicked out of the courtroom?
I'd like to ask you about the expert issue. And as a backdrop to the question, I want to acknowledge that I understand the standard of review here, which is looking at whether the hearing examiner's decision was not supported by substantial evidence. Having said that, the hearing examiner simply says, I heard the guy, I disagree. You then carefully go through the record in your brief and pull out what one might characterize as substantial evidence that would support the determination of level 2. What obligation, if any, does the hearing examiner or should the hearing examiner have to address specifically why he or she, I think it was a he in this case, disagrees with an expert who's come in with all of the weight of statistical analysis and having interviewed the Doe and et cetera? I mean, is it enough to just say, I disagree?
The hearing examiner has to actually give a basis, has to explain why they disagree. And I think this hearing examiner, I know I did a good job, well, I think I did a good job of going through the record and trying to tease out what would be a basis for disagreeing with the expert's evidence. And really what it comes down to, is there a basis in the record, and did the hearing examiner explain it? I think the hearing examiner did explain it in the sense that the hearing examiner goes through pages discussing not only the report, but the testimony, and showing the inconsistencies in the testimony, and then says, I give some, and theoretically, if you look at it, he did give weight to Dr. Bard's belief in the individual's future probation, and that the mitigating weight of the support network. He actually did give some weight to the actuarial testing, but in the end disagreed because the facts that he was presented, he came to a different conclusion than Dr. Bard, and that was really the hearing examiner's explanation. So I don't think it was so far lacking in explanation that it automatically says that the hearing examiner did not put an adequate basis in the record to deny or not accept the hearing examiner or the expert's risk opinion. I think that's really how I look at the case. And again, Dr. Bard, he does these cases, he does lots of these cases, and he does the same thing every time. He has the actuarial testing, and then he only considers the positive mitigating or positive dynamic factors, and he never sees any of the dynamic factors as being negative factors. And that's how he does it every time. So he says, okay, well, he's got a 3.2% over 5 years risk. That puts him in the low risk, and these are the other factors that make him lower. I've never seen him say, this individual starts at a high risk, and these factors add to that risk. And I think that's one of the issues I think the board has with Dr. Bard. And it's just a reality, and it's from dozens and dozens of not only cross-examining Dr. Bard, having his, and doing these appeals and seeing his reports and testimony in these hearings. So I don't have a problem with the hearing examiner's decision to decline accepting Dr. Bard's risk opinion in this matter.
And if you were to offer some professional advice to Dr. Bard, it might be to be a little more open to the other factors.
I think not so much, because when he does do the board's factors, he just says, this applies, this doesn't apply, this applies, this, he's done that. I think what he should do is be looking at the broad picture and try to figure out, what the hearing examiner is going to be looking at too. And he doesn't do that. He just has usually it's a 5 to 6 page report, and he pretty much follows the same pattern every time. And again, I think I've briefed these issues as best I can. Unless there's specific questions at this point, I'd be more than happy to rest.
No, both parties were well represented, and the record should reflect that Doe's counsel did quite a good job, not only here, but also at the hearing below. Case is under advisement, and the case is submitted. Thank you.
Thank you. And I think I see you next week.
We'll look forward to that.
Calling our next case, docket 23P 761, KERYAKES versus KERYAKES. We will hear first counsel for the appellant.
Good day, Your Honors, and may it please the Court. I'm Attorney Ian Kahanowitz, and I represent the appellant, YACOUB KERYAKES. This case is coming from a trial on a modification, complaint for modification, and there's going to be 5 issues that I'm going to be covering. 3 are parenting time, 1 is legal custody, and 1 is attorney's fees. But before I even get into my arguments, I do want to note my brother's attack on the notice of appeal. 4A3 says a notice of appeal filed before the disposition of any timely motion listed in Rule 4A2 shall have no effect. A new notice of appeal must be filed within the prescribed time measured from the entry of the order disposing of last such remaining motion. We filed a motion in March. The disposition of the final 52B and 59 came on March 29th, 2023. It was docketed on April 5th. However, it did show that March 29th was the disposition date. We filed a notice of appeal April 3rd. I will now address my issues. The first issue I have for parenting time is that the appellant is now on Social Security disability. So it was a material change from when the separation agreement and the divorce occurred back in 2017.
Where's that in the record?
Excuse me?
Where would we find that fact in the record?
It should be in the judge's findings of fact.
My copy of the findings of fact that's included in your appendix has handwriting on it.
Yep.
What is that?
At this point, I don't recall.
There are also holes in it, as if it's a draft that was waiting to be filled in. So there are sentences that have just kind of a space at the end of them. Can you explain that?
Unless I know otherwise, any copies that we submitted, or my office has submitted, in my opinion, were okay. They were good to go. I don't know if it was a computer error or a transmission error. To my knowledge, I don't have any clue regarding that. The issue of a plane fare for my client, again, he's on Social Security disability. He used to make $100,000. However, now he doesn't. He's been disabled. He's been arguing with the appellee for a very long time. It's a very tumultuous relationship. And trying to get her to pay half from New Jersey to Massachusetts has been very difficult. And it's a financial burden on him. He wants to see, his minor child's son.
How many trips would that be per year?
I think 8 times a year they ruled on that. There would be 8 trips. And so what his argument was in the complaint was 50% should be paid from each party. He bears the whole costs regarding this.
The judge did, am I correct that the judge did reduce his child support?
Well, there was no child support in this case. If you look at the record, the appellee gets his Social Security disability payment regarding the minor child. So again, the only income he's coming through is through the Social Security disability. So he gives the check for his minor son, Ben, to the appellee. Now, regarding that, it should be similar to a child support matter whereby, to alleviate the burden of any financial hardships, things could be rearranged and help support the fact that he should see his child and there should not be any financial burden that he must bear alone for transport from Jersey to Massachusetts. Now, when the child was much younger, there used to be a chaperone. The child is now in his teen years, and it's a lot cheaper because he can travel alone regarding that. Now that gets me into my second issue, and the second issue is, if you looked at the findings of fact, the judge ruled, I think in March, that the first weekend in March, that the appellant could have parenting time from Saturday at 12 to Sunday at 12. And the judge erred in modifying it that way. We believe that that is not enough parenting time for the appellant to bond with his child. We're talking about going to the airport, picking the child up, taking him back. You're only going to get between 8 and 12 hours of quality parenting time. I don't believe that that's in the best interest of the bonding
So
relationship.
the judge found, and I'm reading from PDF page 18 of the volume 1 of the supplemental record appendix, which has a clean version of the judge's findings in it. The judge found the parenting schedule is modified in the amended judgment of modification. These modifications are made to promote the child's best interests. You, in order to convince us, you need to show that that was an abuse of discretion or an error of law by the trial judge. Why was that finding an abuse of discretion or an error of law?
I believe it was an error of law because although a trial judge has a broad discretion, when it comes to parenting time, to just limit it for a 24-hour period, well, I don't believe that that's going to the best interest of the child. To me, that's a rush, and that's not a time where proper bonding can occur.
Do you have a case that supports that belief?
I do. I have a case here, I believe, if you just let me get to it here, Smith versus McDonald. And in Smith versus McDonald, the non-custodial parent has an independent interest in continued meaningful involvement with the upbringing of the child. And in there, they state that the travel, that it has to be shown that parenting time must be beneficial because the non-custodial parent, and this is true going back to 20831, the statute, it has to be meaningful even though he doesn't live with the child. And I believe that that's the standard that we all must adhere to when analyzing a parenting time. Is it substantial and meaningful?
Do you have a case that says that this amount of time is not substantial and meaningful?
I don't have a case, but the question to ask is a 24-hour period where 2 sections of that are going to be waiting in that airport. To me, it's a rush. It's not meaningful in the spirit of the statute. That gets me to my
Let me ask you this,
Okay.
it just kind of the big picture, because it's an interesting case how this all began. There's joint legal custody, visitation is going on, your client runs into some financial difficulty and he files a complaint for modification. It seems pretty routine at this point, and he's just looking for some relief as far as the costs and so forth. And it takes a turn where he loses the joint legal custody. He gets no financial relief at all, and in fact, he ends up having to pay the bill for $25,000 in legal fees. What went wrong? This went from seeking that simple modification to a complete turnaround.
What the lower court found was that the appellant was quite litigious. He changed lawyers, I believe, 5 times. And so to take away legal custody, which is my other issue, was wrong on the trial judge because the separation agreement, the original separation agreement, and which they both agreed to, granted both of them a say in what's to be regarding the child. However, she always had the last say. She had the final word. No matter what the appellant said, she had the final words. It's written right in there. And to take legal custody away, the judge ruled that he was not making timely decisions. He was giving her a hard time. That might be fine and well, but she still, in the end, had the power to do that. It's like bargaining at a table at a union. I'll give you, Major League Baseball free agency. They had the power. Before free agency, they didn't have the power. The appellee had the power here. And no matter what the judge said about my client being quite litigious or, trying to stop the process, in the end, she had final say. It wouldn't matter what he believed or what he tried to do regarding legal custody.
Well, what I'm driving at is something terrible must have happened here for this to go from this effort to just get this simple modification to these devastating consequences to your client. So, for example, my reading of this indicated that there was a GAO recommendation, there was a judge's order, that there should have been a psychological evaluation done, and your client didn't cooperate with that. Is that correct?
My client did not cooperate. And even though he did not cooperate, there's nowhere in the record that showed that he was harmful to his son or a danger to his son. In fact, the son and him get along quite well. That wouldn't have affected, to take legal custody away, I don't believe. No matter what he would say regarding that, mother still had the power to overrule him on that. To get therapy, again, he was quite litigious. The judge even mentioned in her findings, he filed contempts that were not in her words, not any good for anything. And so I think it was more of a punishment rather than just weighing the facts here that legal custody was taken away. The appellee was no different regarding legal custody. She would never tell him where dates were regarding medical or educational factors. It's in his complaint for modification. He wanted to know. So to take legal custody away when she wasn't following the same standard that he was to co-parent, well, that's a tragedy to my client. The fact remains, look, the judge took a lesser of two evils, in her opinion. Whether she did not agree with my client regarding his behavior as opposed to hers, both of them were wrong. But there was no need to take it away from him because it didn't matter what he would have done, she still would have made the final decision.
So if I follow your argument,
Yep.
I think you're saying that it was an error of law for the judge to change the legal custody arrangement because under the previous legal custody arrangement, the mother had the final say already? Is that what you're saying?
She had all the power. She had the final say. So what is the point of taking away legal custody and given the rationale that he was, not timely in his answers or discussions or trying to just slow down the process? It would not matter because she could have just easily ignored that and said, look, I got the final say, and this is what I think is in the best interest of the child. But that should not have excluded him. Now, in her amended judgment, she says he's allowed to all kinds of I forget the way she worded it, but that's just like throwing a bone at my client.
Well, that's my final question for you. The judge's findings of fact rationale on father's amended complaint for modification, which was amended May 29th, 2023, is that the, for lack of a better term, controlling document here that?
Yes.
Okay, thank you.
It is. To throw him a bone saying non-significant issues, well, that's just a slap in the face if you ask me, especially when both parties were volatile. I didn't think, well, we know that the judge also on attorney's fees didn't consider his financial record. That's one of many issues that a judge has. Now, again, trial judge has a broad discretion to issue legal fees. And in this case, the glaring spot was, well, he's on Social Security disability. $25,000 is a lot of money for someone who's just barely getting by. I believe the appellee asked for 100 and something thousand, and she lowered it. But I still think that would create a financial hardship for a person just living on a stipend from the government. So, you know, in that case, you know, that's all wrong. Another issue for parenting.
Your time has expired.
Oh, I'm sorry.
But I'll give you, 20 seconds to sum up if you'd like to.
The last thing is the celebration of faith in the Coptic Christian. My client wants more parenting time. I do know that the Commonwealth does recognize religious, participation as a material standard for the best interests of the children, the child.
Excellent. Thank you very much.
Thank you very much.
Appreciate your argument. We have from counsel for the appellee. And again, I should have mentioned that this case is partially impounded, so please refrain from using any names of the parties, the child, etc.
Good afternoon. Matthew Barak for Christine KERYAKES. May it please the court. I will start with this. This court should dismiss this appeal as the father's notice of appeal was not in compliance with Rule 4 of appellate procedure. The facts are both undisputed and clear in this regard and demonstrate the error. The initial modification judgment here was filed and docketed on March 22nd. And let me correct, it's the docketing date, not the date that is on, as we know, on the pleading. The docket date was March 22nd of the initial judgment. There was a timely filed motion under Rule 52B and 59, also docketed and filed March 22nd. The timely opposition was filed on March 23rd. The notice of appeal, and the only notice of appeal that was filed in this matter, was filed on April 3rd, 2023. The amended judgment, the operative judgment that is before this court this afternoon, was filed and docketed on April 5th, 2023, 2 days later. The amended findings, again, the operative amended findings before the court, were docketed on April 12th, and the attorney's fees, the order in question of $25,000, which was not part of the original judgment, was not docketed until April 14th, 2023. Rule 4 is clear. A timely filed 52B or 59 motion requires a new notice of appeal upon that decision to the 52B and 59.
Are you familiar with the Roach case, 481 Mass 164?
I believe I am, but it's not cited in my motion to dismiss.
Right. Footnote 2 of that case suggests that, from the SJC, suggests that we have discretion to entertain the appeal. Would you agree with that?
I agree with the discretion, but in this case, I would ask you not to exercise that discretion.
Understood.
And here's why. But here's why. The reason is we filed a motion to dismiss the appeal. It was part of the brief. At no time, up until the present, has the error been corrected. If my brother had come in when we filed a motion to dismiss and sought relief, that's one thing. It's never happened. And as a result, in a case that cries out for finality, we have a child custody case, a modification case. We have attorney's fees that we haven't been paid. And I'd ask the court to take judicial notice that there's a capias against the father in this case as of yesterday in the probate court. My client, the child in this matter as well, deserves finality. And if the appeal was so important, they had the opportunity to correct it, even up until yesterday.
Well, assume that we've taken that issue under advisement. We have not made up our minds on whether or not on the motion to dismiss, but to make the best and highest use of our time, why don't we get to the substance of the case?
Certainly. Regarding the substance, the lower court heard from father, his girlfriend, mother, and had the benefit of not one, but two detailed guardian ad litem reports. The lower court made 38 detailed findings regarding the parties and regarding parenting. Those findings include, regarding the issue related to legal custody, that the father was obstructionist with the minor child's extracurricular activities. He interfered with the child's medical care, therapy, and a neuropsychological exam. When a parent interferes with the basic needs of a child, and the mother here, as in this case, cannot provide that child with his needs because father is delaying and being an obstructionist to making those major decisions, our courts have held it's certainly in her discretion to change legal custody. And that's precisely what occurred in this case. In addition, there was evidence from both the GAL and findings from the lower court that the parties had a toxic relationship. It was described as challenging at best. The acrimony had increased since the time of the initial judgment. They live in separate states. The communication of the parties was not healthy. It was described by the GAL and noted by the lower court as provocative, accusatory, and often incomplete. And what happened here was that rancor between the parties led to extraordinary difficulties in making decisions for the child. It led to delays on making these decisions for health and activities, educational planning and mental health treatment for the child. And those reasons, detailed in 38 very detailed findings, is precisely why she took the step of changing the custody to allow the mom here to have sole legal custody. There's been no abuse of discretion here. There's been no error of law here. The parenting plan was only slightly modified. It still includes almost monthly visits, includes 3 weeks of summer. There wasn't a tremendous amount of taking away of parenting time. It's minor. And as for legal fees, well, one more thing on the legal custody I think that was striking, and I think this alone would allow a judge of the probate court to change legal custody. The father here, and it was in evidence, it's in findings, actually wanted the child to testify at trial. And one of the findings is that mom wanted to shield the child from the litigious nature of this case and the acrimony between these parties. And that judgment alone calls into question the decision-making with dad when it comes to parenting. And I think that was another reason, amongst the additional evidence that was at her trial, that allowed her to conclude what she ultimately did, which was a change to legal custody, a small change in the parenting plan, and then ultimately we get to the legal fees. The legal fees that were awarded were $25,000. The request was, I think that was 21% of our request, so it was a reasonable amount. What the judge at the lower court looked at, and I think what my brother has said to us today, it was true, is that there were multiple lawyers. I think there were 5 lawyers that he had below. There was 2 GAL reports that he did not essentially agree with. We had to go to trial because of that. During trial, it came out that not only had he had 5 lawyers, not only had he amended his complaint multiple times, and there were contempts that were filed, all of his allegations were found to be unfounded that my client had to defend throughout the litigation. But the father hadn't even read the GAL report at the time of trial, and it only was familiar with the recommendations. So because of the tenor of the litigation, I would submit that 21% approximately of the legal fees request was reasonable. And as to the financial aspect,
The father did say that, I believe there was evidence that his lawyer had read it to him. Is that?
yes, that's correct.
Okay.
Yes. But one would think, I would hope, that if you're in a custody case and you have a GAL, an experienced GAL, who's making recommendations, that you really should sit down and read that report before you go to trial. And on the legal fees, the other thing that I think was striking is not only was it a reasonable amount that the court awarded and not the full amount, but as to the financial aspects, which I would, again, and I'll just we filed a motion to strike. I want to stay on the substance as I've been requested to, which I will. But there's no financial information before you. It was not provided by my brother. However, what I will say about that, to answer the question and to shore all doubt, is father was making more money at the time of trial than mother. There was financial statements submitted by both parties, and he had assets of over approximately $700,000, which was greater than my client's assets at that time. So in other words, there is an ability to pay here, but that was not actually, I believe, litigated. And the financial aspect of the case was very muted because we agreed, because at the time at trial he was not working, but receiving an SSDI just to run the SSDI guidelines, in part because he remained in New Jersey and she was in Massachusetts, which had been the case. And in fact, his child support at the time of the separation was $300 a week and went down to zero by the end of the litigation. And the lower court capped, which is a change, the activities to $750 a year in the amended judgment.
Let me just ask you about the fees, because my concern is, as I had said before, the complaint for modification, there's nothing unusual about that. And the fact that people, that emotions run high in these cases, there's nothing unusual about that either. For example, a husband, you know, he's lost his marriage, he fears he's losing his relationship with his child. So that's all understandable. But if legal fees are awarded, doesn't that tend to discourage someone from bringing a legitimate claim to court and trying to resolve it through the courts in a rational manner? That's sort of why we're here. And so when I see fees imposed like that, I fear that it's a punitive measure that's going to discourage people from coming to court and having these issues resolved in a fair and reasonable way. And I couple that with, I noticed in the hearing, in the trial itself, it seemed that it was very difficult for the husband, for the father, to present his case, because I think every page of that transcript, there was an objection, at least one objection, sustained or partially sustained.
See, you're looking at me very closely.
Motion to strike. That's a very difficult situation to be in when you're pleading with the court to hear you out because you have a legitimate concern about your finances and so forth. And not only do you not even get to that, but as I said, it seems to diverge into this other area where it ends up being a complete disaster. Can you help me with that? I mean, I know there's a lot there I've thrown at you.
No, I think it's a good point, but this is what I would say to you, Justice Hodgens, and the panel. Legal fees are a very necessary part of what we do in the probate court. Knowing that we can tell a client at a pretrial, which is often the case, that the judge has given us feedback, and if you want to challenge that feedback, you may run the risk of having to pay part of the legal fees to the other side, is a compelling mechanism to help parties settle matters. So we need legal fees in the probate court at times. Are there times when it may be unnecessary? Certainly, I would agree with your point. But in this particular case, where father had been so obstructionist, where father had brought forth so many claims that were found to be unfounded and that were not found by GAL's investigations. Remember, the way this starts, he brings his claims, they were vetted. In fact, they were vetted not once, they were vetted twice by a neutral third party appointed by the court that the parties pay for. And both times, those claims that he was bringing forth were found to be against him. So the tenor of this case was that it was unreasonable position being sought by a party. And that happens often in the probate court. And without that mechanism to allow a judge to award fees or a reasonable part of their fees, it actually, well, if we didn't have that mechanism, it would encourage further litigation because there would be no risk. So I think it's a very important part of practice in that court. And I think in this situation where you had somebody, going back to your point of objections, I think my recollection from doing the case, because I was trial counsel, is that he was evasive. He was telling his own story, which happens. The judge actually, in this case, had to stop multiple times to correct him and to stop him. There was, I think, a 5-minute pause, if I recall. I think it's in the findings as well, where she instructed him to go speak with his counsel. So his behavior and his demeanor is important in a probate court matter. We give these judges at that level broad discretion. Somebody needs to call balls and strikes. And if somebody's playing outside of that strike zone, we need that judge in the probate court to make a decision. And if that decision sometimes includes attorney's fees, the statute allows for it, so be it.
I hear a lot of spring training going on today. I'm just saying.
Springs in the air. Justice Hershfang, springs in the air. If anything else?
Seeing none, thank you both. Well presented, the case is submitted. Calling our final case on the list. Docket 22P1230. Just a reminder to council that this case is partially impounded. Please do not use the name of the parties or refer to any impounded information. We will hear first from counsel for the appellant, Attorney Denner.
Good morning, ladies and gentlemen. Jeffrey Denner for the appellant. Basically, this case, in a nutshell for me, and I think objectively...
Attorney Denner, I'm sorry, could you pull the mic a little closer just so I can make sure not
course.
to miss a word? Thank you.
Of course. This is essentially a case where the flexibility that's necessary for restraining order cases, from our perspective, collides with the fundamental fairness that you have to get from having a bit more than flexibility when due process is in question. And we believe that there's errors of law here that were basically occurred when the judge basically took material evidence and it was not provided to the defendant in this particular case, and it turned out to be core evidence that basically led to her determination that there was in fact a continuing risk to JM in this case of harassing behavior coming her way if she didn't extend the restraining order.
Your client did not object to the admission of these documents as exhibits, correct?
Well, I think he did. I mean, in his own way. Clearly, he didn't get up and say, I object. But I don't consider that's an effective waiver in the context of this case, as he did get up, as is indicated. Our brief basically sets out, and our reply brief basically sets out our argument. I don't want to be...
Assume we find it doesn't rise to the level of an objection, and I realize that, clients run the risk when they represent themselves of not preserving certain issues. But if it doesn't rise to the level of an appropriate objection, what then?
I would still say there's a substantial risk of a miscarriage of justice to the extent that exists in this civil case, and essentially a failure of justice and a fair result here if he would be held to that particular standard.
Am I correct that a large portion of the documentation consisted of exchanges of text messages?
My understanding is that that we have in February of the quick answer is yes, but there's also in February of
there's some of the defendants, not the defendants, the plaintiff's summaries in there as well.
Yes.
To the extent that the documentation or the exhibit consisted of text messages, I don't see any claim made either before the trial court or here that there's an issue as to authentication or anything else, right?
I think there's an issue of authentication to the extent that we don't know that the copies and the originals were exactly the same. We don't know where the copies came from.
But I don't see any argument to that extent. I mean, if for example, and don't answer this, this is not a question, I don't want to get to attorney-client privileged communications, but if you showed this to your client and your client said, geez, I didn't write these, or none of these aren't accurate, or they're out of context, an attorney of your experience would have raised that before us, surely.
Well, I think an attorney of my experience would have at the time. One of the difficulties was you did have, I understand that the law is that a pro se, to the extent that a pro se is representing himself, he is held to similar standards to attorneys. But in a case such as this, he did try to raise issues relating to, I've never seen this before, I don't know this, what accounts, what are we talking about? And he was shut down pretty quickly. He had not had, if I were an attorney in this, I would assume I would have had an opportunity to view this before the case started. I would look through this, I would go through this with my client, we would have the ability to talk to each other, I would have an ability to understand what we were talking about. He didn't have that at all. A great deal of what the judge was basing her decision on obviously came from the earlier hearings, the 2021 hearings. And that was clear to him because he had that materials, he was able to read that, he understood what that meant, he didn't appeal that when it happened at all. His position has always been that he did not send a good deal of these other emails and a good deal of these other things that came up, and he was surprised by when he found that they were even there, asked the judge, what is here? And the judge said, basically said, I have already made up my mind, I'm not going to share with you any of these materials. So would he have acted as a more prudent attorney if he had had these materials ahead of time and basically understood what his options were and that he should have objected and he should have got up and said that? Yes. But I would also say that a reasonable judge in the context of this case, raising this, getting exhibits in the middle of a trial, not sharing it with him, if the notion came up that a reasonable judge would think that perhaps important rights were being waived, that I would hope that would trigger something in the court's mind that it might make some sense to have some kind of colloquy with this individual to basically say, you understand that you haven't seen these, I understand you haven't seen these, do you understand that by not objecting them coming in, you are willingly and voluntarily waiving certain rights you have, and knowingly are you doing that? Again, I don't have a case that says that that's exactly what has to be done or whatever, but I would say if we're talking about fundamental fairness, errors of law, not wanting to make an obvious mistake in the case and having that as a result, I think that should have been done.
But this was his second time before this same judge on this very same issue, though, right?
I think it was probably the third time, but yes.
So he wasn't really a rookie to how the process worked. He knew that there was going to be a presentation by the plaintiff, and then the judge would turn to him for his version, and then the judge would make a decision. It really wasn't that complicated, though, right?
Again, I hesitate to get in the mind of people who I think are not playing with the same deck of cards I'm playing with as what's complicated and not. But I think in this particular case, in the earlier hearings, I don't think there were any surprises. I think he knows what was coming, and he basically would have objected or would have disagreed and had a narrative ready to rebut what was being said if he didn't think it was true. Here, I think he was taken aback. He is not even though he'd been in court, well, he wasn't in for the ex parte one. He was in there for one hearing before this. And he was, everything he had seen, he had an opportunity to rebut and whatever. I don't think his mind works quite the way that perhaps my mind works or our minds work in terms of either experience or cognitive abilities. And I don't think that was his response to it.
But he acknowledged that he reached out to the husband.
He did.
And he just disputed the fact that he was the person who set in motion the emails or text messages or whatever they were that came in from the hair club and so forth.
Well, I think a lot of the things he couldn't dispute because he really didn't see them. I mean,
But it was her, in other words, she testified to what happened, right?
she did testify, but I would respectfully suggest that her testimony, despite what my brother perhaps has suggested very honorably and respectfully in his brief, I don't think her testimony was nearly as close to what the documents are saying. I think the documents tell a different story, but we'll never really know because he didn't see the documents and didn't have an opportunity to respond to them.
But, I mean, just so I've pulled up the transcript because that helps me, and I'm looking at page 12 of the record appendix, which is, I guess, page 7 of the transcript. So that's after the plaintiff has finished her presentation and offered both Exhibits 1 and 2, and those are marked. And then the judge turns to your client and says, Mr. Blank, what do you want to tell me? And his response is not, I never did any of those things that she has talked about, or, Your Honor, I don't know what that pile of papers is that's just been marked Exhibit 2, or, may I please see that? I've never seen it. And, obviously understand he is not an attorney, but obviously we both understand what the case law is about his obligations in this situation. And his response instead is, I didn't hear, the plaintiff had mentioned something about online appointments. I did not hear the subject. I heard that it was something she had only discussed with me, but I did not hear it. The masks. So I assume people are wearing masks. And the judge says, okay, what did you want to tell me, though? So she's inviting your client to share his version of events. And he asks her a legal question, what is the criteria for continuing the order, Your Honor? The judge answers. And then he begins his rebuttal, essentially, saying, I have not contacted or attempted to contact her. I contacted her husband. I don't believe this has anything to do with it. He obviously has heard the plaintiff's testimony about the mutual friend and the birthday party because he gives his version of that story and then goes on to say that he's not doing these things anymore. He's changed his life. So wasn't there an obligation on the defendant, your client, at that point where he was invited to tell his story to, if not specifically rebut what was in those pages, at least say, I haven't seen them?
Well, I think, in effect, that's exactly what he said. He said, I don't know what accounts they're talking about. I don't know what this is. Now, would it have been better if he had said, Judge, why don't we take a half-hour break, and I insist on seeing these right now? But the judge also was not very accommodating and didn't kind of invite that kind of dialogue. The judge basically said, very quickly, I've made up my mind. I'm ready to make the findings. That's all I have to do. I don't consider that, with truly all respectfully, an appropriate way to proceed in this case. I still don't know, standing here today, what was in these more comprehensive logs and lists that JM put together that as the judge says on page 10 of the transcript, she has provided further documentation today on multiple occasions in the early months of 2021 with other accounts being set up that have nothing to do with her. Okay, I have no idea where she's getting that from other than from these lists of logs and so forth that she has. He has not seen them. I don't know how he would go about basically rebutting something he hasn't seen other than trying to get from the judge the ability to see them. And I think that was shut off rather quickly when the judge said what she said.
So assume, for the sake of argument, that I agree with you that the judge could have done and should have done a better job here of ensuring that, as is the case in a court proceeding, both parties had copies of things that were being offered as exhibits. Why does that failure, assuming, again, for the sake of argument, that it was a failure, create a substantial risk of a miscarriage of justice? And what case can you point us to?
Well, I can basically say that, I mean, I have cases in here, and I'll find them in a moment, but basically, I doubt there's a case that says these specific set of facts lead to a miscarriage of justice. But when the judge is spending a good part of her time saying that what she has to find is that there's obviously, thinking out loud, she has to find that there's a continuing risk of harassing behavior coming to JM from JH. And she can't just do that, or she shouldn't just do that from things that happened in earlier years. She's talked the entire time to this point in terms of what she's basing her ultimate decision on. She's talking about things that have been discussed in February 2nd, February 17th of 2021, the earlier hearings, one being ex parte, he wasn't there, and a universe of events, of events that occurred before that happened in 2020, 2019, things that had happened. The only thing that we really have that relates to most directly to continuing risk, which is very, very obviously very, very important. Continuing risk is this list of this log and list that she's given that talks about events that started in early 2021 and went up to the hearing in 2022. He doesn't know what any of those are. He doesn't. Now, would it have been better if he had said, I can't go any further till I understand exactly what's in these logs, and I need an hour to do that, and I want to sit down over here and do that? Yes, it would have been better. But had the judge done what I respectfully consider would have been the appropriate thing to do if the judge didn't already have some feelings about this guy that I think made, again, not the most even playing field I've seen in a long time, a prudent judge would have had a further, I believe, and respectfully suggest should be the case, done something to reassure herself that justice was being done here, that he wasn't giving up very important rights because of who he was and because how she was feeling about the situation. That didn't happen. That didn't happen. So the only information...
Attorney Denny, your time's passed by 30 seconds, but I'll let you sum up if you wish.
I think everything I've said sums up how I feel, but thank you.
Thank you very much. Attorney Novich.
Good afternoon. Your Honors, may it please the Court, Richard Novich on behalf of JM. Before I get into what I hope is going to be a very brief response, I think most of what I've said is adequately set forth in the brief, and I will do my best not to regurgitate what's in there. I know all of you will read it if you haven't already. My good brother identified two comments that I just wanted to hit direct and head on, if I might. One, I believe I heard him say that his client tried to raise the issue of lack of receipt of the exhibits that were introduced before they were introduced into evidence. And I would respectfully suggest that the record doesn't bear that out. Page 8, and I believe Your Honor Hershfang identified page 12. Between those two pages, there was no question that the documents were introduced to the judge. The judge, I think, invited them. They were handed to the judge. All of this took place in his presence. I think that's a safe bet to say based upon the record, or certainly he was in a position to see, to hear that they were being provided to the court and accepted and remained silent.
But you would agree that, I mean, it's almost a reflex of judges to say, when something's being handed up, to say to the other party, have you seen this? Right? And that didn't happen here.
I don't deny that, Judge, but I can't say that it didn't happen here, and here's why. Having tried a lot of cases, as I'm sure the three of you have done before you went on the bench, it's not unusual to have a litigant, during the course of a rough and tumble trial, hand copies to the court officer to provide to the court, and then do this. That doesn't come out on the record, but it doesn't mean it didn't happen. I can't tell you whether that happened here, but the record is silent, and that creates a factual dispute that I can't answer for you. But I would say, I hear Your Honor, but it doesn't mean that that type of exchange didn't happen. It could have. I don't have the answer to that. The second thing that I would say is, someone asked...
I don't really think that's the issue. The issue isn't whether or not a copy was provided. I mean, the real issue is these materials were provided without notice, and so the real issue is, number one, was it preserved?
Yep.
And number two, assuming, arguendo, it was preserved, what prejudice, if any, was there? To me, perhaps I'm not framing the issue well, but I think that's the key to this case.
And I agree with you, Your Honor, and there's 2 points that I'm going to highlight in just a minute, but the second point that I want to come back to is this. The question about the miscarriage of justice, I forget who asked the question about the case that would best identify that. I believe one case that is important for us to note, which is cited in my brief, is the case of EHS versus KES. That's an SJC decision from 1997, 424 Mass 1011. That case, I think in many respects, is very analogous to the one that we have here. The individual and the gentleman in that case was a 209A case. He was pro se below, and I believe that the record in the SJC decision was he remained representing himself before the SJC as well. And the SJC said, nevertheless, even though you're a pro se litigant, you still have the burden and an obligation to preserve issues such as due process below, and you haven't done that, we're not going to consider it. That's the sum and substance of what that case addresses, and I think that in many respects is dispositive of some of the arguments that are made before you today. Let me get back to the main points that I'd like to make if I could. Number one, the trial court judge in this instance did not abuse her discretion in permanently extending the 250AD anti-harassment order. The decision below should be affirmed for 2 reasons. Number one, as I see it, and I'll get into some of the more detail, and it's obviously in my brief in far more detail, Mr.'s due process rights were not violated in this instance. I will turn to that in a moment, Your Honor. And 2, but even if they were, he waived those claims by remaining silent throughout this litigation and even after the litigation. And I've cited in a footnote a subsequent motion to vacate that he filed. That wasn't before the trial court by any stretch of the imagination, but I do believe that it goes to whether and to what extent he waived any claims to due process for purposes of this court's review. Now, the 2 documents that were introduced into evidence, number one, was what she described was her self-prepared statement. She read right from it. I haven't compared the 2 of them very recently, but the last time I did, they were virtually identical and verbatim. I suggest that the court's later introduction of exhibit number 1 at a minimum was superfluous at best and harmless at worst. Defendant certainly was present for her testimony. I don't believe that there's any dispute about that. He objected to none of her testimony at all. It was put on notice at a minimum as to the nature of her claims. While she could have been more detailed, she did not. I don't suggest that she needed to be more detailed. Mr. was on notice of what her arguments were and what the accusations were that propelled them to that court on that day. Justice Hershfang, as you ably noted, he then responded. He went on for some time in pages responding to some of the accusations, including the fact that he admitted that he contacted her husband. I would suggest that that one admission alone was sufficient to extend the restraining order because it was, in my view, that was a violation of the restraining order, which specifically said no contact, in writing, directly or through other third parties. I think it's a pretty safe bet and a reasonable inference to say he contacted her husband knowing that that communication was going to somehow migrate to her. He did it. He admitted it. That should have been the end of the story.
That communication, though, was essentially an apology, right? Wouldn't it also need to be shown that it was his intent to cause fear, intimidation, or abuse through that communication?
If this was the first instance of my client's efforts to have the order extended after the ex-parte hearing, then I would agree with you. But I don't agree with you insofar as she was looking to extend it permanently at the second round, and here's why. At the moment that the gentleman sent the email that he admittedly sent to my client's husband, there was an existing, without a question, court order directing him not to contact. So there was no question he knew about it. He had received it. The record on the docket reflects that it was handed to him. So he knew he was to have no contact in writing directly or through other third persons. Her husband constituted, in my view, a third person. He did it, he admitted it, and in my view, that would have been a violation. As the trial court judge was permitted to do, she expressly credited my client's testimony. Now, she also credited and took into account the other exhibits that she received, but she also went on the record and credited her testimony. The defendant does not suggest that that was an error at all. Defendant does not suggest the trial judge's order or oral or written findings were clearly erroneous, and he does not challenge the sufficiency of the evidence to justify the extension of the order. All of these things, I think, are significant. While Exhibit 2 that was introduced does provide more detail and it fleshes out some of the general facts to which he testified to and also set forth in Exhibit Number 1, as I mentioned earlier, the trial court record is unclear as to whether, as I mentioned earlier, did this happen? Without any statements in the record, it's unclear, and I can't answer that.
Our record is now also unclear. What was this?
Fair enough. At a minimum, and this goes, I believe, to the heart of Your Honor Neyman's comment at the beginning of this, Mr. does not deny several things, all of which I think are fatal to this appeal. Number one, he was physically present when Exhibits 1 and 2 were handed to the court. 2, he was in a position to both see the documents being handed and to hear the trial court solicit them and mark them as exhibits. 3, he was without a doubt aware that the documents were being introduced in his presence. He did not ask a single question relative to those documents at the time that they were being introduced. He did not object under any circumstances to their introduction, and I know my brother had a different take on that. I believe the record says otherwise. No disrespect, I think the record says otherwise. At no point did he tell the court, as Your Honor had identified, hey, what is this? I'd like to take a break. I want to look at these. Can you give me an opportunity? That was something that came out in the Idris case that my brother relies upon and cites in his brief. This case is very distinguishable for a variety of reasons, but one in particular was in the attorney in Idris. Upon learning that the trial court judge had documents that he did not have or she did not have, immediately asked the court, what is this? Can I get copies? And was ignored. Justice Blake, when she wrote the opinion on the case, acknowledged that the transcripts of the record reflected efforts, plural efforts, of counsel trying to get the documents that the court had that the defense attorney did not have. And there were a variety of other things and failures in that case that are not present here, but that was the most analogous one. Again, not present here. Mr. made no effort whatsoever, immediately or otherwise, throughout the course of this case to get documents he clearly knew had been given to the court. I view that as disinterest. I'm not sure that he's entitled to any further protections. That's my opinion. I don't have a case that cites it. 7 months after the decision came out, he then filed, as I mentioned, a motion to vacate, again, not before the trial court, but I do believe that it goes to, did he preserve the argument of due process and constitutional questions? I don't believe he did. Now, I'll sum up in 30 seconds, I hope. In this instance, there should be no dispute in the record, and I don't believe that Mr. disputes, that before he filed his appellate brief with this court, he did none of the following 3 things. He never raised any constitutional questions below. He had the opportunity, but he didn't. He never even mentioned the word due process or constitution ever. And I know that there's an argument about authenticity, but again, that was not something that was ever raised at any point in time as well. Now, in many respects, I would say this case is analogous to the case of Smith versus Joyce. That was a 209A case. And in that case, there was a plaintiff's affidavit that had been filed, but the defendant in that instance chose not to read it. He made an argument that he was deprived of due process, and the SJC essentially said, you had that opportunity to raise it below and you didn't now, it's waived. very similar facts, I think, here. I'll conclude my argument with an analogy taken from a recent decision issued by Justice Georges of the SJC. If you'd indulge me just for a minute. The name of the case, it was decided about 2 weeks ago. It doesn't even have a citation. The name of the case is Commonwealth versus Kamudi. It was decided on February 21st, just about 2 weeks ago, maybe a little less than 2 weeks ago. And in the opinion, he likened the efforts of the defendant in that case to what he referred to and defined in footnote 8 as a Hail Mary pass. I suggest that's precisely what's happening here, with all respect to my good brother. He failed to raise any due process challenges below. He failed to raise any challenges in his motion to vacate, and the first time he did that was here. I hope none of you pick up the ball and get into the end zone with it. And with that, I rest my case. If you have any questions, I'm happy to answer them.
Well presented by experienced counsel for both parties. Thank you. The case is submitted. Thank you very much to the clerks and court officers. That concludes our session. Thank you.
All rise. Let's go stand in recess.